He, all persons having business with the appellate division draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division First Department. Oral arguments for today, March 11. So please, as you probably are already aware, only ask for the time that you actually need in order to get out the salient points of your arguments. We are fully familiar with your arguments. We've read the briefs. The red light is for you, not for us. If in fact we have additional questions to pose, we will certainly do so. People v. William Ibanez. That matter is submitted. Piggott v. J.C. Happy Garden. Did they submit yesterday afternoon? Oh, okay, well, matter is submitted, thank you. Matter of Jose and Zesta. That matter is submitted. Smalls v. Feingold. Did you want any time in rebuttal or no? 5, 2, and 5. Grasso v. Twibley.
Your Honor, on behalf of respondents, appellant's counsel emailed me and said that he would be submitting. So again, unless the court has any questions for me, I'm happy to concede my time and submit.
Matter submitted. FPG Maiden Lane v. Bank Lammy.
Your Honor, here for the appellant, 6 minutes and 4 for rebuttal, please.
Respondent request 6 minutes, please.
5, 2, and 5. People v. Andre Chambers.
Ron Kuby for appellant, I'd like 7 and 3, please, Judge.
6, 2, 6. Grandelli versus the City of New York. I'm sorry, who do you represent? Home Depot. And you're requesting, I apologize.
Christopher Donadio, plaintiff respondent from Gary Constant. Your Honor, I request 6 minutes.
6-2, 6-2, 2. Turner Construction v. Flight Center.
Howard Rosen of Carr Agency representing Turner. Request 14 and 1 minute for
14 what?
minutes.
Really? Okay. Yes, sir.
Michael Rogers on behalf of Western Hotel.
Yeah, 7-2, 7-2. People v. Aaron Kish. Five, 2, 5. NYP Holdings versus the New York City Department of Social Services. 6 and 2 and 6. Structure Tone v. Merchants Preferred.
Appellate requesting 7 and 3.
Respondent, plaintiff respondent requesting 3, please.
Who do you represent?
Plaintiff respondent,
Structure Tone.
respondent,
Merchants. 6 and 2, 3, 3 and 2. People v. Clinton Fuller. 5-1-3. Century Indemnity versus Brooklyn Union. Brooklyn Union versus Century Indemnity. Those cases will be called together. So please, the time you're requesting, that's going to be for both appeals. 6-1-6. First case for argument is People v. William Ibanez. I'm sorry, that was submitted. I apologize. First case is Smalls v. Feingold, right? Yes. Yes, you may proceed.
Thank you, Your Honors. This is an action for medical malpractice and wrongful death pertaining to the defendant's respondent's failure to take appropriate actions to cause the plaintiff's decedent's.
What was the inappropriate action, or what was the departure that
The
you
principal
allege occurred?
The principal departure is the failure to refer the decedent to gastroenterology on an urgent basis. The initial urgent care visit, which is at issue with Dr. Johnson, it's documented that she referred him to his internist, his primary care doctor. But first of all, that wasn't done on any kind of an urgent basis. Second of all,
Why should she have referred him back to his primary care doctor on an urgent basis?
actually she needed to refer him to a gastroenterologist.
Okay, why did that need to occur on an urgent basis?
Because he presented with a constellation of new concerning gastroenterological signs and symptoms, as well as new presumptive iron deficiency anemia.
What did she do for him when she saw him at the emergency?
She did a physical exam. I believe she ordered an abdominal ultrasound, and she did blood work.
What did that abdominal ultrasound reveal?
Nothing of any significance. Nothing.
So then, if that revealed nothing of any significance, and he's presenting basically with symptoms of maybe ulcer or upset stomach, what is the urgency that he needs to see a gastroenterologist at that point?
Because the new iron deficiency anemia is presumptively indicative of bowel cancer. Yes, it could be.
That by itself, or that in conjunction with other things?
Actually, that on its own, according to
On its own?
On its own. He also had the symptoms, but according to my experts, the new presumed iron deficiency.
I actually did not see how, or in your experts' reports, how they explain specifically how the blood levels, the blood values, it would indicate small bowel cancer.
Because it doesn't directly, it indicates new presumptive iron deficiency anemia, which could be bowel cancer. And
It could be other things as well, isn't that the issue? And also, I saw in the reports that small bowel cancer is a very rare form of cancer as well, is it not?
It is rare, but it still comprises a significant portion of bowel cancers. And they didn't know at that point, they hadn't done any testing at that point to rule out any kind of bowel cancer.
Can you tell me what the significance of the urgent as opposed to just a regular referral, like a regular referral?
Well, I'll tell you what
referred.
was urgent was the referral or consult with gastroenterology when he came to WestMed in March of 2014. He saw an intern, he saw a PA that day, PA Klein, and she got a gastroenterologist in there to see him that same day. It's a multidisciplinary practice. They have all different kinds of specialists, all different kinds of providers.
But when he saw that PA Klein and she referred him to the gastroenterologist, he came back presenting basically a worsening of issues. But when he saw Dr. Johnson, he got better, didn't he?
Well, I believe there was a waning of his symptoms thereafter, to the time when he saw Dr. Dennett. But the symptoms can wax and wane. That doesn't alleviate the concern. The principal concern, which necessitated the workup on an urgent basis, actually, as I stated, was the blood work, the new iron deficiency.
Yeah, counsel, I'm glad you said that, the iron deficiency, because that's where I want to go.
Yeah.
Defendants experts said that deficiencies, most often caused by nutritional deficiencies, particularly, I'm almost done, particularly, iron, and that's not a serious condition. And so with that, I didn't see anything from your experts to, refute this and then say why anemia is indicative of bowel cancer.
Well, because it could be bowel cancer. It could be other things.
How? Was it in there?
Was what in there?
Did your expert explain
Yeah.
how is it that an iron deficiency is sort of like a telltale sign of a small bowel cancer?
Yeah.
I'm not sure.
I don't think he
got into
did.
how they explained it, but
Well, see,
the
no,
important
They
thing
didn't.
Is what
the
is
point is
appropriate-
you're talking about the departure because there was not an immediate referral. And then the reports by the various experts say, yes, anemia may be one indicator of small bowel cancer, but it also is an indicator of other things. As my colleague mentioned, nutrition. I think the decedent was morbidly obese, if I'm not mistaken. So there was an issue in terms of health-wise, in terms of eating, et cetera, nutrition. And so the question again, and I posed this to you previously, we're talking about a rare form of cancer. So again, what was it about the anemia which would immediately point to small bowel cancer and rule out any other maladies?
It wouldn't necessarily point to small bowel cancer specifically, but it would point to a significant possibility of some form of bowel cancer. With any sign, symptom, blood work finding.
Fine, so did any of your experts say that specifically? I did not see that in the reports as to why that would be something that would require an immediate referral.
It's a presumption. It's a presumption that exists under standards of medical care that the finding of the new iron deficiency anemia is indicative of bowel cancer, and it has to be ruled upon that finding. It has to be worked up and ruled out.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. Alejandra Gil for the defendant respondents. As Your Honors all articulated in your questions, you hit the nail on the head here. Plaintiffs' experts did not say what about the anemia lab work specifically was presumptively indicative of bowel cancer. In the appellant's brief, counsel makes kind of a concession saying, well, of course, it could be due to nutritional deficiencies, but their expert actually never said that. Dr. Johnson did refer the patient, Mr. Smalls, to the primary care physician within 1 week. It wasn't, go see your primary care physician when you have a minute. It was within a week, and Mr. Smalls did not do so. So then the next appointment was...
At some point in time, as your friend mentioned, he apparently was doing better in terms of, I think they had referred him to another physician, but they also stated he should improve his nutrition, he should get rest, those types of things. And apparently they worked, according to him, or they believed that it worked, not knowing that he did have the cancer.
That's correct, Your Honor. When he went to see Dr. Dennett in January of 2014, and again, just a reminder, there's only two appointments at issue on this appeal. It's the urgent care visit in November 2013 and then the January 2014 visit with Dr. Dennett. And when Mr. Smalls saw Dr. Dennett on that date, he did report that he had some improvement, that his symptoms were coming and going. And at that point, Dr. Dennett did refer him to a gastroenterologist.
And what did that gastroenterologist that Dr. Dennett refer him to, what did that doctor find?
So the gastroenterologist, it was Dr. Feingold, who was a defendant in this case, but then the summary judgment wasn't opposed. He ordered some of the tests that plaintiffs' experts say should have been ordered, and they didn't diagnose the cancer. And that's another big issue in this case, is the causation, because plaintiff's expert is saying, well, if they had referred him urgently, he would have seen a gastroenterologist in February, and the cancer would have been diagnosed at that time. But the facts in this case directly belie those opinions, because he did see a gastroenterologist in March, Dr. Feingold. Then he saw another gastroenterologist on 2 occasions, I believe, between March and July. And it wasn't until July that the cancer was diagnosed.
March and July of 2013?
Of 2014.
2014.
Correct.
And I believe it was a Dr. Costin who stated that it was probably present November 2013?
Yes.
And it had metastasized by November 2013?
Right. But regardless, it wasn't diagnosed because it was such a rare form of cancer, and sometimes it takes multiple tests and time to make the diagnosis. So plaintiffs' experts don't explain how a cancer that wasn't diagnosed until July by 2 different gastroenterologists could have been diagnosed in February. They don't articulate that. They're assuming first that if he had been referred that he would have gone. Second, that they would have performed certain tests, that his symptoms would have been the same as they were when it was diagnosed in July, and that at that point the test would have made the diagnosis. Those are all assumptions that are not supported.
When was the ultimate diagnosis made?
In July of 2014.
And by whom? Was that after the test by the gastroenterologist?
It was by a gastroenterologist, Your Honor. Sorry, I don't remember the name of the gastroenterologist.
Is that the one in Montefiore?
I'm sorry?
The gastroenterologist at Montefiore?
I believe it was at Montefiore.
Did the physical exams raise any concerns?
No, our experts opined that the physical exams could have been consistent with any type of gastroenterological process. It could have been an ulcer, it could have been C. diff, it could have been GERD. They were non-specific symptoms.
And he was given medication for an ulcer, wasn't he?
He was.
And he improved.
He did. He did have some improvement. The symptoms were waxing and waning. We can see that. But the point is here, they have not articulated why an urgent referral was necessary based solely on this anemia finding. The experts didn't specifically address that the anemia could have been due to nutritional deficiencies or other conditions. And they don't acknowledge that he was referred to his PCP within a week, and Mr. Smalls decided not to see the PCP for whatever reason. And this diagnosis wasn't made even when he was sent to a gastroenterologist months later. So on that basis, it is our position that the lower court's decision should be affirmed, as there was no issue of fact raised by plaintiff's experts. Thank you.
Thank you.
So just a few points I'd like to hit on there. Counsel stated in her argument erroneously, as in her papers, that a plaintiff's gastroenterology expert assumes and opines as to what would have happened. That's not what actually plaintiff's gastroenterologist opines to. He opines to what should have happened, what the timetable should have been. And in all honesty, based on what actually happened, going by plaintiff's experts' opinions, Dr. Solney's opinions, the subsequent gastroenterologists who treated him and ultimately worked him up, they were too slow in their workup as well. If there was causation as to that, during that time frame when those doctors were involved, those doctors would be defendants.
Wasn't there something in the record by one of the experts that regardless, I think he was stage 4, and they broke down what the life expectancy was for stage 4, that even if it had been discovered earlier, he would have been stage 2 or something of that nature, and it still would have been a short lifespan?
Well, the different experts on different sides differed on that issue, which is sort of the hallmark of summary judgment motions in medical malpractice cases. The defense gastroenterology expert was of the opinion that the cancer had already metastasized
by 2013.
In November 2013.
Right.
But plaintiffs' 2 causation experts, the gastroenterologist and the oncologist, both differed with that and said no, it hadn't. So, I mean, that's just purely issue of fact, and that's assuming that the defendant's gastroenterology expert is even qualified to opine as to this causation issue because it's cancer, and so it's really an ongoing.
Is there any significance to the fact that once he did go to the gastroenterologist, they still were not able to diagnose they still did not diagnose the small bowel cancer?
Well, their workup was too slow, according to my gastroenterology expert. Their workup was too slow. They took a matter of months to diagnose him. It should have been more like 1 month.
So with that, did your experts indicate how the treatment would have been different if he was referred earlier? Because I didn't see anything, in the affirmations to say, if it had have been earlier, this is how the treatment would have taken place.
Actually, I think the plaintiff's oncology expert, appellant's oncology expert, acknowledged that his treatment may have been the same, but what would have been different would have been his prognosis, his life expectancy.
That's when we go from the stage 4 to the stage 2, right?
I believe he was stage 3B at the time
Stage
of
3B.
diagnosis. But if he had been timely diagnosed, it would have been stage 1 or 2, I believe, according to the plaintiff's oncology expert.
Is that speculative?
No, that's not speculative. That's based on the pathology, because at the time of the surgical, the surgery, the pathology showed only 3 of 19 lymph nodes positive for cancer. And so, as an oncologist, you can extrapolate back from that and opine within a reasonable degree of medical certainty, as my expert did, that it wouldn't have been stage 3B. It would have been an earlier stage earlier on. By say February of 2014, if he had been diagnosed by then, since it was only 3 of 19 lymph nodes positive.
Thank you. Thank you both.
Thank you, Your Honors.
FPG Maiden Lane versus Bank Leumi. Yes, you may proceed.
Good afternoon, Your Honors. Please the court. My name is Stephen Mandelsberg. I'm with Thompson Coburn, and we represent the defendants' appellants lenders on this appeal. In denying summary judgment dismissal of the two remaining categories of claims in the amended complaint for breach of contract and declaratory relief, after this court in two previous appeals, appellate decisions in December 2022 and April 2024, dismissed other claims in the complaint, the lower court disregarded applicable law and undisputed or admitted facts in the record. This is so for at least four reasons. The first is that the lower court failed to consider that the borrower had anticipatorily repudiated and breached the parties' written loan agreements as amended, which were admittedly entered into
Was this
by
argument made
sophisticated
before
parties.
Supreme Court counsel?
What's that?
Was that argument made before Supreme Court?
Yes, Your Honor. It was replete in the record. The record contains the March 31st letter. It contains the pre-negotiation agreement. The law is clear in this department and others that an appellate issue can be raised at any time as long as there's no new facts being adduced. And these are not new facts. In fact, these facts were present on either of the prior appeals. The only issue is whether or not, as a matter of law, based on those facts, there's no issue, genuine issue of fact to be tried. So the first reason, the anticipatory repudiation by the March 31st letter is spread all over the record. And the court...
My question was, did you argue to the Supreme Court that that letter repudiated the agreements?
The motion, the argument before the Supreme Court focused on the consequential damages clauses and the redundancy of other claims, but it was certainly mentioned in the appellate record. The March 31st letter, the pre-negotiation agreement, and the breach.
I know that that is in the record, that letter is in the record, but was the argument made that based on that letter, the agreements were repudiated?
That argument was referred to, yes. It wasn't specifically made below, but it doesn't need to be made on this appeal because it's not a new fact, and the law is that if a party anticipatorily repudiates a contract, that constitutes a basis for the lender not providing further funding. The law is clear that no magic words are to be used for an anticipatory repudiation. The clear thing is the context and the words. And there are
Words
four...
and the intent have to manifest a positive and unequivocal intention to repudiate.
That's correct, and it did.
In the March 31?
It did, in four separate ways, Your Honor. First, that it could not and would not comply with agreed upon deadlines that were set forth in a loan agreement that was amended on March 13th, 2020. It said it's likely impossible to comply with these deadlines because of, and I quote, a complete inability to secure construction labor and supplies necessary to complete construction of the project on schedule and on budget. It cited as its sole reason for not doing so COVID-19, the COVID-19 pandemic.
Well, it says so long as the pandemic continues, we may be unable to engage in sales activities and therefore may be unable to repay the loan within the planned time frame.
That's correct, Your Honor. And they, in fact...
Is that unequivocal?
Yes, because when you couple it with the last paragraph...
Well, again, these circumstances made it likely impossible. We may, so long as the pandemic continues, we may be unable to engage, and therefore we may be unable to repay the loan within the time frame?
Yes, Your Honor, because look what it also says, that delay makes a complete inability to secure construction labor and supplies. And it also
So
asks
long as the pandemic continues.
but it asks for a open-ended extension of the deadlines. No, it's not 30 days or 60 days, or for as long as the pandemic continues. The request here was, we need an open-ended extension. And mind you, this is the third time that an extension of these deadlines were granted by the lenders. This is a project that has spawned considerable litigation, articles, including the most recent one in the New Yorker of February of this year, called The Leaning Tower of New York. This is not a case in which the lender arbitrarily stopped funding. This is a case after 1 strike, 2 strikes, 3 strikes, you're out. They're saying they could not comply. And there's one other alternative reason.
And we'll listen to that on your rebuttal. Thank you so much.
Thank you, Your Honor.
May it please the court, William Adams for respondent. In response to your question, Justice Mendez, the answer is no. The repudiation argument was not made below. And that actually matters because while this court does have discretion to take up pure issues of law that are raised for the first time on appeal, this is not a pure issue of law, and it depends upon the development of the summary judgment record. There's plenty of disputed facts with respect to repudiation, with respect to election of remedies, with respect to the contractual argument that my friend on the other side has invoked, and with respect to waiver. And those...
Did they continue the contract after the March 31st letter?
Absolutely, Your Honor. There's at very least a tribal issue as to that, but the record shows that they, in fact, approved multiple of the RFAs and allowed the request for advances and allowed for the funding of some of those. And so under this court's precedent, you have to make an election either to affirm the contract and continue performance as they did here, or declare it terminated and sue for breach. They chose the former, not the latter, and it's too late now to come up on this appeal, certainly when it wasn't raised below. And for them to pursue that. I think it's important, Your Honors, to recognize that this is a court of appeals, not a court of first instance. And allowing them to raise issues like this for the first time would really permit not just this court to hear summary judgment appeals of issues that were raised, but issues that could have been raised, and deprive you of the benefit of the trial court's assessment of the summary judgment record. Further, with respect to the record that was developed below, back to Justice Higgitt's question, this was not an unequivocal, positive expression of intent not to perform or express any inability to perform. As Justice Weber, as you were pointing out in your colloquy, the language here is quite qualified. It's quite conditional. The word is likely impossible, may be unable. And even where there was a reference to the difficulty in getting supplies and the difficulty in getting labor, the upshot of that was that it is likely impossible to perform under the current deadline. There's nothing unequivocal, unqualified, definite, and clear about that language. So unless this court has any further questions, we would urge you to affirm the denial of summary judgment and allow this case to proceed to trial.
One question.
Yes.
In their briefs, do the appellants, in essence, concede that that argument was not raised in Supreme Court?
Yes, I think they do concede that, Your Honor. They say that there were facts, as you heard today, the facts are in the record and perhaps were presented in the background section of their summary judgment brief, but I see nothing in response to our argument that shows where it was actually presented as a basis for summary judgment below. And just to be clear, this is not a hyper-technical waiver violation. They've come to this court and pivoted and adopted an entirely new theory of summary judgment. This court respectfully suggests that this court can affirm both on that basis and on the existence of the tribal issues that are in this record. Thank you.
Thank you.
First of all, Your Honor, this is not entirely new. This argument was raised in the initial pre-answer motion to dismiss this lender liability complaint. It's not a new issue when a different panel of this court considered the appeal from that motion and dismissed some fraud-based claims. The letter here is not a mere benign request, as my friend would characterize it, to extend deadlines. It's an absolute statement that they can't comply because of COVID. But independent of that, and this is also in the record, the lenders here had a contractual right to withhold funding if it reasonably determined that the project could not be completed on time or within budget. The March 31st letter says that it can't complete on time and within budget. If that's not a basis for a reasonable determination, I don't know what is. And this appeal is not brought as the prior one before discovery was taken. There's been extensive discovery, and there's nothing in the record, any record, that suggests that this March 31st letter wasn't sent or that the borrower didn't know what they were doing. This is a case of a borrower very sophisticated. And the last point I want to make about waiver and approval of funds, there was no funding made after this March 31st letter. What did happen was that the lender engaged in workout discussions in order to try to obviate a litigation. And between April 2020 and August 2020, those discussions continued. Now, there are provisions in loan agreements which have been repeatedly enforced that says that the lender doesn't waive its rights because it delays exercising its remedies. It doesn't waive its rights because it previously approved funding. There's $90 million that had been funded of a $120 million credit facility. And the pre-negotiation agreement executed in April says specifically, if I may finish this point, Your Honor, says specifically that there's no reliance on oral assurances and the only modification agreement has to be in writing. You know how the borrower responded to these workout discussions? They sued the lenders on August 4th, 2020, in response to a forbearance agreement. The consequence of the borrower's argument is that we waived our rights because we entered into discussions. So that would lead to a result that every time a lender receives a letter like this, it should immediately sue, which is not consistent with the court. So for these reasons, we think that this was clearly an anticipatory repudiation, a breach, and by the way, none of the deadlines were complied with anyway.
Thank you. Thank you both.
Thank you, Your Honor.
People v. Andre Chambers.
May it please the court, my name's Ron Kuby, and this case presents the question of whether a conviction can stand based on a plea allocution that affirmatively negates the geographical jurisdiction of the court. In this case, facts are simple enough. After the defendant was asked by the court where in Manhattan the shooting took place, he said, I murdered him in the Bronx.
This happened in the Bronx.
Yes, Judge.
What he stated was this happened. Where did you shoot him? What location? The defendant stated, I think, 6 times in the stomach. The court says, what part of Manhattan was it that this happened? What was the address or the neighborhood or the area? The defendant responded, this happened in the Bronx. So this plea and the allocution by Judge Uvilla occurred in 2004?
Correct.
And now the defendant is appealing, well, the defendant brought a 440 in 2023.
Correct.
So that's like over almost 20 years later, right?
Okay, yeah.
Okay. So the defendant was present at the time of the allocution, obviously, because the defendant was the one who stated that the murder took place in the Bronx. So there was no surprise to the defendant. The defendant and his attorney had a copy of the indictment, which again showed the location or stated the location of the murder in the Bronx. I'm not understanding why there was no first of all, I'm not understanding why there was no statement made at the time of the allocution hey, wait a minute, this is Manhattan and the crime occurred, the actual murder occurred in the Bronx. I'm not understanding why there was no motion to withdraw the plea prior to sentencing, and I'm not understanding why after sentencing there was no motion made.
Okay, let me try to address all three of those, if not necessarily in the order that you.
Appreciate it.
It's the only person in this proceeding who did not have a law degree was the defendant. The prosecutor had a law degree, the judge had a law degree, the defendant says the Bronx. Now, that's the clearest possible negation of the court's geographical jurisdiction. Now, you may say, well, the defendant personally should have done more.
Well, no, when I say defendant, I meant when I said defendant, I meant his representative, which was his attorney. So why did the attorney? I mean, again, if I'm the judge at this time, red lights are going off. You know, like what is going on here? We're in Manhattan. This occurred in the Bronx. No one says anything, and I'm not saying there was any responsibility on the defendant, but certainly his attorney to say something.
Well, I would say the case law, as I understand it, places that obligation first and foremost on the court, and as a fallback upon the district attorney to say, well, say for example the.
Well, that's because you're a defense attorney, so therefore you're not taking any responsibility whatsoever, right?
No.
That was rhetorical. Go ahead, Mr. Kuby. Go ahead.
But if you want to blame defense counsel for overlooking this, the same thing that everybody else overlooked.
It's not a blame. It's I'm not understanding. It is so glaring. I do not. It is so glaring.
Yes.
Why was it not brought up? I just that is what I do not understand. And why was it not? Why was there no appeal?
Okay.
Immediate appeal or motion to vacate.
Okay. Certainly, we all agree it was incredibly glaring from the face of the record, and that many somebodies with law degrees should have done something. Agreed. Nobody did. Agreed. On whose head does that fall? The one guy who doesn't have a law degree. As to the appeal, this is what, and we've been working, the prosecution and I have been working to try to reconstruct what happened. So at sentencing, defense counsel says, I will stay on the case for 30 days after the defendant is notified of his right to appeal. And indeed, defense counsel that day submits at least one copy of a notice of appeal to the Supreme Court clerk's office. And that's indicated in the exhibits that have been submitted. The defendant also submits a pro se notice of appeal. There's no record of anybody having received it besides the DA's office. But at this point, both the defendant and defense counsel, in their own ways, say they wish to appeal. The problem was that for reasons we don't know, that notice of appeal never made it to this court. So the appeal was never docketed. Literally, I think in the court's rules, the appeal was never taken, and hence it was never perfected. But we can resolve this if resolution is what the court wants. Because it was, at least one copy was submitted with the Supreme Court appeals clerk in a timely fashion within 30 days, we can simply declare the appeal docketed now, take this round of briefing as briefing on the direct appeal, this argument on the direct appeal, and the court can make a decision as if the court were hearing the direct appeal 20 years ago. Or you can convert this to a writ of error coram nobis, and simply find ineffective assistance of counsel for counsel's failure to make sure that documents A were transmitted to this court.
The problem with that is that none of this is in the record before us.
Yes, it is.
The record, well, no, we don't know why. We don't know whether a notice was filed. We don't know what happened. None of that information is in the record before us. What we have is a 440. We have a 440 wherein the judge denied the 440.
With respect, Judge, Exhibits A, B, and C, which were filed by the prosecution to expand the record, put all of those facts before the court. Most notably Exhibit C, which now is in the record, which is from the Supreme Court appeals clerk, indicating that March 11th, 2000 and whatever it was, 2004, a notice of appeal was filed, and that notice of appeal was never transferred to this court. In addition, Exhibits A and B, also filed by the prosecution under stipulation, indicate that documents, at least, that were served on the DA's office indicating the desire.
So procedurally, again, will we not need some type of motion by the defendant to convert it, and then we would need a reply by the people as to whether or not they consent to that, et cetera?
Would you like that? That can be done.
I would like a lot of things. The issue is whether procedurally that is what is required.
You don't, with all due respect, you don't need that. You're a court of general
So did you wish
jurisdiction.
to, I mean, your time is
Yeah,
up,
no, I'll
but
sit.
do you want, yeah.
I'll sit.
Did you want to address the 440 issue in terms of Judge Conviser and his determination as to the 440 and the denial of the 440?
Would you like me to do that now?
Yes, please.
I'd be more than happy to. The prosecution, well, we've already dealt with the appeals question. But turning to the merits, the one argument the prosecution advanced before Judge Conviser, the only argument, was that somehow, because there are allegations in the indictment itself, there are like 7 of them, 6 of which in the conspiracy count would have established geographical jurisdiction had they been proven, admitted to, or even alluded to.
Because the alleged transaction in terms of the exchange for money, the exchange of money, et cetera, that took place in Manhattan.
According to the indictment, that took place in Manhattan. The intent was formulated in Manhattan. The payment was made in Manhattan. Pretty much everything happened in Manhattan, except for the actual murder, which took place in the Bronx. So certainly that could somebody, like the prosecution, when asked, is there anything else, could have done what the prosecution did at sentencing too late, which is to say, oh yeah, there are these other things that give this court jurisdiction. Instead, the prosecution argued to Judge Conviser that somehow the indictment its allegations can be imported sub silentio into the plea allocution. And they just can't. That's just not.
He pled guilty to the murder in the second degree, which was the intentional murder, as opposed to conspiracy to commit murder.
Correct. And certainly, if they wanted to establish geographical jurisdiction, the easiest thing would have been for the prosecutor to stand up and say, yes, I have one question. Did you formulate the intent to commit this murder in Manhattan with Mr. Rajan? And the defendant would have either said, yes, fine, you've done it, or no. Then you have a problem. Everybody retreats to their corners, works this out if you want this plea to go forward. But none of that happened here. So things could have happened, but they don't get to say that because we think we could have done this, therefore we did it.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Connor Burns for the people. Just to begin, the 440 court did correctly deny defendant's motion for a number of reasons. First, on the procedural issue, Justice Conviser did correctly find that the motion was procedurally barred. The defense counsel is correct. We've stipulated that a notice of appeal was timely filed, and I know he takes issue with the fact that this court never received a copy, but I think that has no bearing on the fact that under the CPL, once the notice of appeal is filed with the Supreme Court Clerk's Office, the notice of appeal is deemed timely. And then again, it's not disputed that.
Then the issue is that the appeal was never perfected.
Correct. The appeal was
Then
never
why
perfected.
was the appeal never perfected?
Well, we don't know the reason for that. I mean, again, the defense counsel did state that the trial counsel said that he would stay on the case for 30 days, that he to assist the defendant, and that he advised him of his right to appeal. So again, we don't know the correct reason, but we can presume that that defense counsel advised him that the next steps after you perfect, you would then I would file a brief on your behalf. And the defendant, he got a very good deal here, and maybe that's the reason he didn't decide to perfect his appeal. He was given the minimum on a second-degree murder charge.
Maybe, or maybe counsel never followed up with him to perfect the appeal, and it it languished and now is, presumed dead. So it could be the defendant didn't want to appeal. It could be that his counsel dropped the ball and didn't aid him in perfecting an appeal.
Certainly, certainly. We don't know the exact reason, but I think defense counsel here, after the Justice Convisor denied the motion on procedural grounds, didn't.
Did you raise that procedural bar, the 440-10 2C?
Not below, Your Honor. No, not below in the 440.
And why not?
I'm not sure the reasons why. I think again the 440 focused on the merits, but a court does have the duty to review the record and see whether or not any procedural bars would apply, and that's what Justice Convisor did here, and correctly so, because again there is no reason why, or at least stated on the record why the appeal was never perfected, and therefore it would be an unjustifiable failure. And then just moving for a few other reasons why the claim here regarding the plea is also unpreserved. There was no, as the panel has stated, no motion made by defense counsel, no objection raised at plea or sentencing to this alleged defect, and I know counsel argues that the preservation exception applies here, but it's inapplicable to this case. The failure to do so means that this claim is now unpreserved. And the claim is also waived, and I think that's the reason why a claim regarding the court's venue is certainly waivable, and by pleading guilty, a defendant does so, and here that's certainly the case.
Geographical jurisdiction is something that does not have to be preserved?
No, it's a claim to regarding the defect in
No,
the
my
plea
question
needs
is,
to be
does geographical jurisdiction have to be preserved?
I believe that also would be an issue that would need to be preserved before appeal. And again, it's something that is an argument that is waivable by pleading guilty, which again did occur here.
So can we reach the issue of the lack of geographical jurisdiction, although it was not preserved?
I mean, this court certainly has interest of justice powers, but I would argue that would need to be preserved and was failed here. And then just moving to the merits.
I'm sorry, but in your view, in light of this peculiar procedural history that's been recounted, in your view, what remedy, if any, does the defendant have here? What procedural vehicle is available to him to advance the claim he wants now, if this isn't the appropriate vehicle?
Well, the appropriate vehicle was certainly to raise a direct appeal. I mean, this is a record-based issue, as Justice Convisor found, and defense counsel doesn't dispute. So the correct vehicle would have been to raise a direct appeal.
Would have been, because he can no longer, that's no longer open to him. That's no longer an option.
Correct. And now 20 years later on a 440, where it would be unduly burdensome to now grant the remedy that defendant seeks and take his plea back and go back to as we were 20 years ago. So that's the reason that direct appeal in this procedural bar was enacted in the 440. It would suggest and promote direct appeals as opposed to waiting, as in this case, 20 years later, to bring a 440 motion.
So maybe the procedural remedy, if there is one, would be a 440 for ineffective assistance of the trial counsel in ensuring that the notice of appeal got to us and/or quorum nobis.
Perhaps that perhaps could be an avenue available to defendant in addition to this appeal here.
I'm sorry, I took a lot of your time. You wanted to talk about the merits?
Yes, thank you, Your Honor. Yes, just briefly on the merits. I know reading the record, it does seem, the record of the transcript when defendant pleads guilty to the conduct that occurred in the Bronx. But I think, and defendant tries to paint a picture of confusion by all parties, there certainly wasn't one. From the outset, it was clear, the people were clear. It's clear from the disclosure forms, the indictment, that yes, the murder took place in the Bronx, but that all of the conduct leading up to the murder, which was recounted in the overt acts in the indictment of the conspiracy count, took place in Manhattan, and that was the basis for venue in Manhattan. The Bronx or Manhattan could have been a proper venue. The prosecution moved forward in Manhattan based on those overt acts. Again, the intent to murder was formulated in Manhattan, and again, also those acts in furtherance of the conspiracy. So again, for those reasons, and again.
But the allocution should be clear in terms of exactly what occurred, because as stated, the defendant pled guilty to the murder in the second degree, which is the intent to cause the death of, not that again that it was done based upon some type of conspiracy or that type of thing. It was intention. He pled guilty to intentional murder, which occurred in the Bronx.
Correct. But again, I think by pleading guilty, again, defendants waive any issue with venue. So by pleading guilty, you are then saying that I'm raising no other issue, I'm accepting the offer, and I'm pleading guilty for those reasons. And again, while there maybe something different should have occurred, I don't think the issue that defendant raises actually affected the venue. New York County certainly was a proper venue, and I don't think that, I think the record supports that.
Thank you.
If there are no questions, we have issue affirmed. Thank you.
To the extent that brother counsel is arguing that a guilty plea, by virtue of it existing, automatically extinguishes defects in the allocution, that's just wrong. And there's dozens of cases that stand for that principle. Second, the notice of appeal was filed with the clerk, but the appeal under this court's language was never, quote, taken.
So the appeal was filed with the clerk in New York County Supreme Court. New York County Supreme Court.
Yes.
Right.
The appeals clerk in New York County Supreme Court, they received it, but they never forwarded it to this court, so the appeal was never taken, and it has to be taken before it can be perfected. So either the clerk erred, which has been known to happen in the history of Anglo-American jurisprudence, and it's not the defendant's fault, or defense counsel, who said that he would remain on the case for 30 days to just oversee this process, didn't do what he was supposed to do for whatever reason, in which case it's the defense counsel's fault.
What is it that you are seeking? What remedy are you seeking?
What remedy? I'm overturning the conviction, withdrawing the plea.
Based upon?
The defective allocution, and they can go back. The indictment gets reinstated.
So was it a knowing and voluntary plea?
It was not knowing in the sense that the defendant affirmatively negated geographical jurisdiction. Could it have been a knowing plea? Sure, it could have been, had somebody bothered to say, okay, dude, I know that you did this in the Bronx, but it's also true that you got paid $10,000 to do it in Manhattan, right? The defendant would have said yes, or the defendant would have said no. No, I had nothing to do with this other guy.
But the remedy that you are seeking is based upon an argument that it wasn't knowing and voluntary because it was based on, it negated the geographical jurisdiction.
Correct.
And you did that pursuant to a 440.
Yes.
So the question is whether a 440 is a proper vehicle for that, and the answer appears to be no.
Well, the answer is an appeal is the proper vehicle, but we've already discussed what happened with his attempt to appeal. You can't say he waived his appeal when both he and trial counsel, in each of them, were submitting notices of appeal. Or, as Justice Higgins suggested, we could file a petition for writ of error coram nobis and sort of repeat this whole process. But in fairness, Judge, why? I've done petitions for writ of error coram nobis in the past, and the remedy.
Well, perhaps because that's what perhaps that's because that's what the procedure is. The other question again is why wait 20 years in order to bring this to the court's attention?
Well, there's no due diligence requirement. So I don't have the.
There's no due diligence requirement, but at some point in time, it does become a little bit of a problem where you're now. There should be some type of, I think, some type of explanation as to why we're waiting 20 years to assert the fact that the actual crime, in terms of the murder, that the crime that he pled guilty to, occurred in a different jurisdiction.
Fair enough. There should be some explanation, just not because the law requires it, but just because it would be kind of nice to know what happened here. Had the prosecution raised this below, not opposed an evidentiary hearing, and raised this issue like, why did you wait this long? we may have an explanation, and it may or may not be satisfactory to this court, but they didn't, so we don't. And again, they don't get these sort of endless do-overs. All I have to say is that I understand these things don't have to be perfect. The allocutions don't have to be formulaic or perfect. I am just suggesting that before a man is allowed to toss away or has 15 years of his life and perhaps the rest of his life tossed away, there should just be a little more care taken by all the people with law degrees in charge of taking care of stuff.
Thank you. Thank you both. Grandelli versus the City of New York. Yes.
May it please the court, my name is Nicholas Herzler, and I represent Home Depot in this matter. Your Honors, fundamentally, there has to be some quote-unquote characteristic or condition of this customer that puts Home Depot on notice that he's dangerous. There are...
So again, procedural issues. This is a 3211, yes?
It's a 3211D.
3211D.
Which means the court gave us 3 opportunities. They said, look, we made a pre-answer motion to dismiss. Now we decided you need to do a little more discovery, okay, with leave to renew.
Well, the discovery was for a limited issue, was it not, in terms of the duty?
It was for the limited issue of what Saipov's conduct was. And for that purpose, we produced the clerk, Mr. Caratero. We made the motion again with leave.
What his conduct was in terms of whether or not his conduct in some way imposed upon Home Depot a duty or an obligation not to, well, impose upon Home Depot an obligation to check him out further and not to rent the truck to him, right?
Correct. And Mr. Caratero testified and explained this customer comes in, he has a valid license, he has a valid credit card and insurance card, which is 3 forms of ID. And there's nothing unusual about it. Not only was there nothing unusual about him, but he affirmatively put Mr. Caratero at ease by doing things like bantering about beaches in Tampa, Florida, which is...
Sorry, before we get any further into the weeds on the merits, let's see if we can all agree where we stand procedurally, all right? Your motion that generated the order on appeal here sought relief under 3211A1 and 7, right? It's a second renewed 3211A7 supported by evidence.
And we also cited 3211D and also C.
Okay. But the court did not convert the motion to one for summary judgment.
The court did not explicitly do that?
Well, hold on. Let's not waste time here. Under the law, the only way the court can convert a motion from 3211 to 3212 is by an express written notice to all of the parties, right?
Yes.
Yes.
But...
Okay, so the but would be a summary judgment course was charted.
Correct.
Okay, did the parties opposing your motion chart a summary judgment course?
Absolutely. We produced all the discovery that they wanted.
The first argument in their affirmations in opposition to your motion highlighted to Supreme Court that it was a 3211 motion the court was considering.
And not a motion for summary judgment.
They tried to make, okay, they tried to put it in that posture, but the truth is we gave them 3 rounds of whatever
But the problem is, again, if they're specifically stating this is not a motion for summary judgment, then how, without notice from the court, can it convert it to a motion for summary judgment?
Because first of all, we don't need that because it's a 3211D where the court says, let's do the discovery and then figure it out after that, whether they have a valid cause of action after we've done the depositions and the documents, which we did. So the court under 3211D at that point is no longer in an A7 posture. It's no longer in an A1 posture.
What it is in this odd creature that the courts have, the decisions have established over the last 50 years is an A7 motion supported by evidence.
Correct.
So what you have is not a you're not challenging the facial sufficiency of the pleading. You're saying that your evidence is so powerful that it conclusively refutes the plaintiff's allegations.
That and the fact that the parties under the case law charted a summary judgment course because everybody laid bare all their proof. And everybody...
Is all the discovery in this case complete?
Absolutely, as far as Home Depot is concerned, because we
As
asked,
far as Home Depot is concerned, but as far as the other parties are concerned, is all the discovery completed?
there could be outstanding discovery for those other parties. I don't know, but the point is, we asked them in our lower court motion papers. We made very, very clear. Please, if there's anything else that you need from us, tell us what it is. We produced Annie Marquez for her deposition, even though she's a former employee. We produced her anyway, and we gave them.
Sorry, I've taken a lot of your time with the procedural portion of this. So marshal for us, if you will, the evidence, whatever procedural lens we're going to look at it through with respect to the issue of Home Depot's knowledge.
So it's very revealing when you look at if you look at the plaintiff's brief, which is where you would expect to find the relevant evidence, and what they tell us is, well, what's so suspicious about him? He visited Home Depot 3 times in 10 days. Well, first of all, that comes from a bulletin that has to do with storage of his.
Well, that was the FBI as well as the other law enforcement bulletins and materials, brochures that talked about how to spot a terrorist, right?
They talk about storage facilities.
Storage
That's in storage
facilities.
facilities. Okay, this is a retail store, number one. Number two, they say he's wearing sunglasses. Again, that has to do with storage facilities. It's not suspicious, but there's no even proof that he was wearing sunglasses.
Also, the same name should appear on all of the documents, right?
I'm glad Your Honor brought that up because, come on, his middle name is missing from the rental agreement. He gave us his true first and last names on his driver's license, which was his real identity. He didn't try to hide or give an alias. Just because it's missing the middle name Habibulovic, which is very long and hard to spell, that's missing from the rental agreement. That doesn't mean he's trying to hide his identity. It was his real name. He was not trying to, tell Home Depot that he's somebody else or use some terrorist trick to say I'm somebody else. That's not what happened. He was arrested and it was proven that this is who this person is. So they put up this smoke screen. They say, look at all these red flags. Like he left the middle name off of the rental agreement. He's wearing sunglasses. And what
Now,
really
the
gets
sunglasses, that was outside, but not
It
in
was
the store.
outside, not in the store. And then they say it's suspicious that somebody has an out-of-state license, a Florida license in New Jersey. Well, in Home Depot, in that instance, is supposed to investigate and check and see how long have you lived in this state? Because we need to know, because if you didn't register your license within 60 days, then you might be a terrorist. And what is that going to lead to? Some sort of police state? Every time you go to Home Depot, they have to know how many days you've been living in the state?
Was there any issue with his driving record?
He had a perfectly valid Florida license. Yes, he had a prior suspension from 2 years prior. Yes, he had an insurance issue and an equipment issue from 2 years prior to this incident. He had a valid license under Byrne versus Collins and under the New Jersey statute. We have to rent him the vehicle. We can't not rent him the vehicle just because.
But so the Home Depot employee did in fact check the driving record.
They didn't. He scanned the license with the computer. He knows at that point it's a valid license. We didn't know about the driving abstract.
How did you learn about the violation in Pennsylvania and the suspension?
That came out in discovery after the case was filed. But the bottom line is it's undisputed he had a valid license. That's all we need.
What about the New Jersey statute that requires a lessor of a vehicle to create and maintain a ledger containing certain information about the lessee?
It's a 1949 statute. It's very old. It says you have to check his license, make sure that his name and his address are listed so that if somebody comes along and they're a plaintiff in a case and they need to find this driver, then they can find him, which we did. We had all of his information in the computer, not 1949 style in a written ledger, but in a computer. This is the way things are done these days. We had that information, and they try to make a big deal about, well, under the statute, you're supposed to ask him, it says his description of his business and the purpose for which the vehicle is to be
So
used.
the information was kept by Home Depot, but just not in a ledger form, but on the computer.
Correct. And the whole issue of that statute is we have to preserve his identity so that somebody comes along, a plaintiff, and needs to identify this person, they can sue him, which we did. They know who he is. It's his real name. There's no question about that. That information was preserved in, a 21st century way.
Thank you. You have time on rebuttal?
Thank you.
May it please the court. My name is Chris Donadio, counsel for the plaintiff's respondents. We believe that the lower court decision should be affirmed for 2 reasons. Once, defendant Home Depot did not demonstrate that they met their burden to do due diligence to ensure that the information provided to them was trustworthy. And second,
Why would they need to do that when they're presented with a driver's license that has a photograph that looks like the person that is right before them, and then they get presented with a credit card that has basically the same name as the person that is before them?
sure, 2
So
reasons.
why should they go any further?
2 reasons, Your Honor. It's the climate that we were in at the time. The FBI had given bulletins and warnings to Home Depot. They admit they had those. They also admit that they did not provide that to the gentleman who was renting the truck, Mr. Carcetero.
Did not provide what?
Did not provide him the information regarding trucks being used for ramming and terrorist attacks and what the things were to look
They were
out
supposed to
for.
tell the terrorists about how terrorists are using trucks to ram?
No, their employee, Mr. Carcetero.
Oh,
He
they didn't
admitted
tell
he
the
was-
employees?
Yes, he was admitted, they admitted he did not receive that information that had been provided to Home Depot.
Did the FBI require that every renter go through this list to make sure that the person that was renting was not some type of terrorist?
The FBI did not require it, but
And I
the
thought
FBI
that the-
suggested that.
And wasn't this all also for storage facilities as well?
Many of the bulletins were for storage facilities, that is correct, but it is also information that can be used to determine whether somebody may be trying to use something for something illicit.
Right, and I thought the only bulletin that dealt with a facility such as Home Depot was, the only factor was the sunglasses.
On those bulletins, yes. That when
Right,
people are
and-
not making eye contact and wearing sunglasses, that is something that is a red flag in that bulletin.
Right, so here we have the employees from Home Depot stating that he did not have on sunglasses, he made eye contact, and then there was this banter about the beaches in Tampa.
Yes.
So again, assuming that there's some duty on Home Depot to do something more, how would that comport with your allegation that somehow that it raised, I believe you stated in your papers that it raised suspicion that this individual was a terrorist, or that the individual was going to use the truck for nefarious purposes?
Sure. So we don't know about the sunglasses directly at the time of the lease because Home Depot has lost that footage.
Well, no, the footage shows him wearing sunglasses outside of Home Depot, doesn't show him wearing sunglasses inside, and the individual who rented the second vehicle to him, the male, did not state that the defendant had on sunglasses at the time.
As was included in the record, there's a still photo from one of the cameras that was working that day that we included that does show him inside wearing sunglasses.
Not sunglasses, they were clear.
He's wearing sunglasses in the photo that's in the record, that was in the papers, the underlying papers.
I thought those glasses were clear, but again, when he is speaking directly to the employee and the transaction is taking place for the vehicle, he's not wearing sunglasses, nor is he doing anything to obscure his face.
He was not at that moment, per Mr. Carcetero's testimony. Again, we don't know exactly what was happening because we don't have the footage of that. But we do know that he was
Wouldn't it be
providing-
relevant? I mean, that he's not obscuring his face during the transaction?
It could be relevant.
Because that's one-on-one, and the transaction apparently took a certain period of time. We had to go through the paperwork, he had to give him his license, et cetera, and the banter about Tampa. And this entire time, the employee is looking directly in his face.
That is correct, and that is something that a jury should consider as to whether or not that should have raised concern or not in light of the other things.
And what are the other things?
Sure, that he provided different names. There were different versions of the name going on.
The only different version of the name, as stated by your friend, is the fact that one of the documents did not include his middle name.
That's not entirely correct. It used
What
a
else
different
was
last
there?
name. It used Sapov as one name, and it used the Halsinovic name as a last name as well. So there are different last names going on the rental agreements that Home Depot documented. They were all variations.
The rental agreements or the return of the vehicle?
They were on the rental because there were 2 different rentals. There was one prior and then the day of. He had about 3 or 4 different names that were his name. but there was Sapoff was used as a last name on some of the documents, and Halasinovic was used as the name on some of the other documents.
But they're
Again,
still the
question of
same,
fact.
it's still the same names. It's just the way it's written.
But again, somebody who is renting the truck doesn't necessarily know that. It requires further investigation in light of the New Jersey statute. That does require, the statute lays out a duty for someone like Home Depot who rents trucks. One of the things that you must do is get a description of the business. Counsel misspoke. Mr. Carsitero, the employee of Home Depot, said, I never got a description of the business of why he wanted the truck.
So when you go rent a truck to at Home Depot, you have to let them know what it is, what kind of business you're engaged in?
Per the New Jersey statute, it is the duty of the renter to get a description of the business of the person renting the truck, number one, and get a description of the purpose that they're renting the truck at that time. And Home Depot's employee, he admitted, and there's no dispute about that, he admitted, I did not get a description of the business, and I did not get a description of the purpose of why he wanted the truck. So for a motion to dismiss, for them to stand here and ask for the case to be dismissed, when they did not follow those duties that are statutory in the state of New Jersey, we believe that it was right for the lower court to deny it, and any of the issues regarding the weight of suspicion of the different things that we've brought up are questions of fact for a jury we would submit to this court.
Thank you.
Thank you.
May it please the court, my name is Diane Toner, and I represent the defendant respondent Hudson River Park Trust. On this appeal, we are aligned with plaintiffs in opposing Home Depot's motion to dismiss. And as a procedural note, I think if you review the papers below, it's clear that the parties were not charting a course for summary judgment. And in fact,
What additional discovery would you need?
Well, I think the depositions that were done of the two store personnel revealed that, in fact, they had no training and no awareness of any potential
So what
terrorist.
additional discovery would you require?
So one of the points that was raised by Home Depot was that we did not produce any evidence that they knew that Saipov was known to the FBI or that they had these bulletins. So we would like to know what the Home Depot knew and how they could have reacted differently in training their personnel, because all of the evidence they had put forth as far as the lack of suspicious behavior on the part of
I saw in the papers there was nothing in terms of an allegation as to whether he was on any type of terrorist watch list or anything of that nature, or if Home Depot was in possession of this watch list, if he was on it, or if there is one, or that any other company such as Home Depot would be in possession of such a watch list.
At this point, all we know is that he was known to the FBI, and we don't know what knowledge Home Depot
And the
had.
FBI will not state whether he was on a watch list or he was not on a watch list or whether there is a watch list. So if the FBI won't divulge this information or doesn't have the information, what makes you think that Home Depot would?
We don't know. We've only deposed the two people who were working in the store.
And did you ask them?
No, we asked them if they received any training about these security bulletins or about FBI.
They said no,
They
right?
did not. So they did not know. So they had no training in which to judge the behavior, the conduct, the appearance of customers coming in who might potentially use their vehicles for a criminal activity. Because they didn't have this information, they can't then say that it proves that the customer then was not suspicious at all. Because
But again, well, they can certainly state that the customer was not suspicious based upon how the individual presented. But then again, this goes back to the whole issue as to whether or not there's any duty on Home Depot to, to ensure that an individual is not suspicious, or, that they rent to a certain individual and not to other individuals? You still have an established duty, I guess.
Well,
is what I'm
Home
getting at.
Depot, I think just several months before this attack, in June of 2017, there's an internal email in which they are disseminating warnings about vehicles being used in ramming attacks.
And I believe their employees stated that they had not received that, right?
Correct, correct. So did Home Depot as a company have a duty to train their employees who were dealing with the renters in a personal way, to train them to observe, discern, and inquire, not...
So did they have such a duty, and based on what?
I think they did have such a duty based on the information that they had regarding the potential use of vehicles in terrorist attacks and the guidance they were given to share this information with their store personnel so that they could collect information and observe whether
So prior to this incident, had there been any other incidents where a vehicle was rented from Home Depot or a store such as Home Depot that was then used in a terrorist attack?
I don't know off the top of my head whether, I don't know what you
Was
mean
there
by a
anything in the
store
record
such
to
as-
that? Was there anything in the record about that?
So in the record, I can tell you where the warning as for vehicle ramming attacks is at page 1758, and this was disseminated to Home Depot. And so there's a list of attacks that had occurred globally with the use of vehicles. And so Home Depot was alerted to this specifically and was directed to share this information with its employees, and it did not. And so then the judgment that was made by its employees has to be seen in this context. So they were not suspicious because they were not alerted to be suspicious. So everything that they viewed was done in the light of not anticipating that these trucks could possibly be used for a criminal activity.
Let me ask you, that FBI indicator of terrorist criminal activity, didn't they, in essence, acknowledge that a lot of these indicators may also by itself be conduct that is basically illegal?
Yes, so it's not as though there is a bright line rule here. How do you judge what somebody is going to do with the vehicles that you're renting them?
Right, so the one thing that they are interested in is, as has been discussed here, listing different names, having a license that doesn't match the credit card that you're using, and then a bunch of things that basically anybody could do at any moment, like enter the same store more than one time.
With sunglasses on.
With sunglasses on. So how would the renter that has had an interaction with this individual that shows that renter a license and a credit card basically with the same name, that engages the renter in a friendly conversation, that has been there before and rented a vehicle and returned it without any issue, how would that renter somehow be alerted that this guy is a terrorist?
So what I would say is that the value of the evidence that they have put in is not as good as it would have been if these employees had been trained properly. So if they had their employees trained to be on the lookout for possible indicators of criminal or terrorist use, and then those employees submitted their depositions and their affidavits, and they said, look, I had training from Home Depot. I knew what to look out for, and this guy was not suspicious. Everything was on the up and up.
Basically what you're saying is the fact that the man showed up in their store and rented a vehicle from them and did not look suspicious at all, that is irrelevant. What matters is that they were not trained.
No, what I'm saying is that they were not suspicious to the store clerk because the store clerk was not trained to be suspicious.
Or is it because he was not acting suspicious?
At this point, you can defer that question to the jury, but I would say at this point, at this point where we have not conducted full discovery and where we asked for discovery in opposition to their motion, and where the court, in deciding this motion, said, in light of the discovery thus far, then the claim should not be dismissed.
You know, what's interesting is that attorneys come before us all the time and they say, you know, if you rule this way, you're going to open the floodgates to, you know, to all these different lawsuits and these causes of actions, et cetera, and it's going to be a deluge of cases. This is a case that if we held that stores such as Home Depot that sell certain equipment or certain products, if we held them to a duty to ensure that the individuals that they are selling to are not suspicious or not terrorists or not going to use the product in a nefarious manner, it would open a floodgate because you're imposing a duty on, you know, some 19-year-old kid who is selling, who's renting trucks to someone from Home Depot. I find it very interesting. But thank you. You have time on rebuttal. Home Depot?
Thank you, Your Honor. I just make a few quick points here. Under cases such as Byrne versus Collins, which was a Second Department case, 2010, there's no duty to conduct an investigation.
Well, yeah, your friend stated that the requirement was that you state not only the business of the person who is leasing the vehicle, but also the purpose for which they are leasing the vehicle.
Right. So the problem with that is if we take a jury and we put them in a box and we say, hypothetically, if things had turned out differently, and if he had asked those two questions, would he have suddenly blurted out, I'm a terrorist?
Yeah, I know. I don't think he would have said, yes, I'm leasing the vehicle because I'm going to go and commit a terrorist act. I don't think that the person would have been honest.
There would have to be some evidence upon which a jury verdict of that nature would have to be based. In other words, some evidence that he was nervous or did something wrong, or that he would have, you know, that those questions would have led to something. It's pure speculation.
What about the argument also that there's no training, that Home Depot did not provide any training to its employees, although there was that memo that was sent out to the employees?
It really circles back to what I said at the beginning. There has to be a characteristic or condition of the customer. These were warnings that were blasted out to all the thousands of Home Depot stores. Be on the lookout in general for these things. If you tell people to, what evidence is there that training would have made a difference with this customer? There has to be a characteristic or condition.
Does a Home Depot employee working in a New Jersey store have discretion not to consummate a lease transaction if the employee sees fit? Or is there a law that compels
Yes.
Home Depot, just broadly speaking, to lease vehicles?
100%, Your Honor. For example, a customer comes in and he's visibly intoxicated. At that point, the employee has to say, I can't rent you the vehicle, right? There's cases that talk about that. And there's cases that we cite in our brief where there was allegations of intoxicated driving and things of that nature, and the court in the Appellate Division in Byrne dismissed the case because there's no evidence that at the time of the transaction. Or there's other cases we cite where there was someone who was 80 years old, and then she buys a vehicle a few days later and something terrible happens. With the benefit of hindsight, something terrible happened. And look,
But short of that, Home Depot would be under an obligation to lease the vehicle to the individual.
Absolutely. And we can't discriminate against people, because they're Muslim or because they appear a certain way or anything else. And the last thing I want to say is this was a terrible tragedy. This is a horrific incident that happened, and we're not denying that. It really is. But we're just saying that it would just be inappropriate based on the evidence that's been presented in this case to hold Home Depot responsible.
Thank you.
Thank you.
Thank you all. Turner Construction v. Flight Center. Gonna come here.
May it please the court. I am Howard Rosen from the law firm of Carr and Abramson. We represent Turner Construction Company in this matter. They are the respondent appellant, and we bring this appeal from the trial court's denial of Turner's motion for summary judgment. The case involves Turner's construction of the TWA Hotel and Conference Center located at John F. Kennedy Airport. This appeal asks the court to do three important things. First, to enforce a statute, that is the Prompt Pay Act. Second, to enforce the plain meaning of the contract requirements for owner payments and the conditions for the owner's right to make a liquidated damage claim. And the third, importantly, is to uphold the burden on a defendant of coming forward to oppose plaintiff's prima facie entitlement to summary judgment. First, with respect to the Prompt Pay Act. The Prompt Pay Act required Flight Center to approve or disapprove Turner's invoices in writing within 12 business days of their submission. Flight Center was required to prepare and issue written statements describing those items in the invoice that they were not approved, that were not approved.
So how do we deal with the fact that the opening paragraph states, and I'm going to paraphrase, right, that the terms and conditions of a construction contract shall supersede the provisions of this article and govern the conduct of the parties. So how does it apply when you have this language?
Well, in this case, there's nothing in the contract that would supersede the Prompt Pay Act. Moreover, Judge Warrock held in his 2020 decision that Flight Center was subject to the Prompt Pay Act, and that's the law of this case. His decision is attached to Turner's reply brief. It's document number 94. So that issue was raised and resolved in the earlier, the first decision in this case. But there's nothing inconsistent with the provisions in the contract and the provisions I'm referring to under the Prompt Pay Act. They both have to be considered in terms of the obligations on the defendant.
So you're saying that the contract didn't have any methods with respect to invoicing and payment. It was silent.
No, it wasn't silent at all. In fact, we rely on Section 9.2.1 of the contract, which sets forth very similar provisions with respect to the obligations on the owner to make payments. 9.2.1 provides that after a pencil requisition was reviewed and submitted as a final application for payment, the owner has 30 days to make payment. And it says that if the owner disapproves a portion of the application for payment, the owner shall give the contractor written specification with detailed particularity of the amounts disapproved and the reasons therefore, and then pay the balance. That's totally consistent with the Prompt Pay Act. I think they go hand in hand. There's no conflict between those provisions.
But in order for this provision to take effect, they should have gone through the entire process of the, the pencil copy?
Yes, and they did.
The review, and then they have to pay once they approve.
What the record makes clear is Turner would meet with the project representative for Flight Center. They would review a pencil copy of the requisition. They would resolve any questions regarding what was being billed, and then Turner would then submit a final requisition to Flight Center. Flight Center would take that final requisition and attach it to its funding draws from the lender, get paid, and then in this case, starting with requisition 17, they would hold back payments from Turner without qualifying, either satisfying the requirement to have objected to amounts that they were holding back, or alternatively, to make a timely payment within 30 days. Either way, they have violated both the Prompt Pay Act and the contract itself in this regard. And moreover, the record makes clear that of those draws that Flight Center obtained from the lender, it held back $17 million of payments on Turner's requisitions. That's in the record.
That's from your invoices 17 through 44?
From 17 to 44, the short paid requisitions, correct.
That's $17 million.
That's just there, $17 million.
Mm-hmm. What about I'm sorry.
No, don't be sorry. So what about invoices 45 through 50? Was a pencil copy submitted there?
No, there was no pencil copy because the Flight Center's project representative had already left the project. But Turner submitted the requisitions, and Flight Center failed to either reject them or pay him, approve them. They just ignored them, which is a violation of the Prompt Pay Act, and it's also a violation of the Section 9.2.1 of the contract. Flight Center did not comply with either the Prompt Pay Act or the contract with respect to any of the 27 payment applications that were submitted by Turner that are the subject of this case. Now, the trial court, Judge Borak, found that there were things that created an issue of fact as to Flight Center's good faith in not complying with the statute and the contract. He said in his decision, he said Flight Center discussed payment disputes at meetings with Turner. There's nothing in the record to support that finding. He said that that Flight Center wrote to Turner advising of the disputes. And
This is the email thread?
Yeah, 6 emails. And then he said, and I'll talk about those in a minute, he said Jason Garone testified, this is the judge talking in his decision, that he advised Turner of disagreements during the pencil copy process. The trial court is wrong in each of those instances. The record does not support any of those findings, none of them. If the 6 emails, you can find them in volume 24, pages 576 through 590. I hope it's apparent to this panel, just from reading these emails, that they utterly fail to establish a question of fact with respect to Flight Center's good faith, because there's nothing in them to show a compliance with the statute and the contract. Keep in mind, we're talking, I'm sorry, ma'am.
What about design changes or design issues that were coming up?
I don't know how to answer that question. I don't know which design issues you're talking about that had anything to do with the payments of the requisitions. So I need clarification on that question.
You have time on rebuttal.
Good afternoon. May it please the court, Your Honor. Michael Rogers on behalf of Flight Center Hotel. Justice Borak, in denying their motion for summary judgment, was correct. First of all, to point out where in the contract there's language with respect to what's material breach. There's 2 interesting points that I want to bring to your attention. One is that they failed, Turner, to timely complete the project and to achieve substantial completion in September of 2018.
Did they have an obligation to timely complete the project?
Yes, they did. And in fact, I'm going to read that, Your Honor. It states that the failure to timely achieve substantial completion shall constitute a material breach of the contract documents. That's Article 6.3 in the contract, and it's at the record at 1.24. Now, with respect to the withholding of payment when there's a dispute, and there were disputes on this project, and it states in Article 11.1 is that the contrary to what Turner is saying, a good faith withholding of payment does not constitute a material breach of the agreement. That's the express language from the contract.
Can I go back to, you read Article 6.3 in the contract?
Yes.
But this article basically takes effect if you have a GMP, which is a guarantee.
That's a red herring argument, Your Honor, if I may respectfully state.
I see it here in the contract.
And what a GMP is just a method of pricing a contract. Whether it's a GMP, whether it's a lump sum, whether it's a cost plus, that was just to trigger to start the 24-month period. When we have a GMP, then we have our 24-month schedule.
Well, wasn't it something discussed that if you wanted to have a guarantee schedule, you needed to enter into a GMP or get a GMP amendment?
No, a schedule is separate and apart. The pricing of the work, this was a project where it was $277 million of work. They made it a cost plus, and going against that budget. The fact of the matter is that whether it's a GMP, whether it would be a lump sum or a cost plus, they agreed that it was a 24-month schedule. Even at the trial level, the justice said, you just can't say that you go on ad infinitum. You can't say that there was no requirement or time requirement in a construction project to complete the work. That just doesn't make sense. It doesn't make sense on any
Consistent
level.
with what I think Justice Mendez was referring to, how do we address Section 3.8, which says Turner will exercise reasonable care in preparing its work product schedules and estimates, but does not warrant or guarantee its work product estimates and schedules, except as may be included as part of the GMP amendment?
Well, it also, because other provisions in the contract provide for time being of the essence. The language in the contract to CMA 6.2, 6.12, and 8.5, they refer to time as of the essence. And times of the essence requires a specific date, or at least have a schedule, where you will have a date somewhere which will identify when substantial completion should be achieved. And the only language in the contract with respect to time is 24 months. To state, as they said, once there was no GMP, nothing counted, well, if you want to play that game, let's just do it across the board. If it doesn't count for a 24-month schedule, maybe it doesn't count for any payment, any objections that have to be made. Maybe it doesn't count for the amount that has to be paid on a cost plus. Maybe it's a different rate. No, everything was agreed upon. They just changed, as the contract was being finalized, the mechanism for how it was going to be priced. The fact, and there were disputes that we have, which is why we were holding payment. And it makes sense. This was a 24-month project. If you look at it, and he said 17 is the first one was a dispute. We weren't short paying. We were holding back monies because we had a disagreement.
But
because we were worried.
Didn't your person on site, Garone, in essence, do a walkthrough with Turner's people and approve the invoices that they sent, 17 through 44?
It wasn't, he was part of, he would walk through it, make his recommendation to his employer, which was the Flight Center Hotel. But there was pencil copies, there was disputes as to work that as the project went on, they found out there was overbilling, and that's what some.
But part of the walkthrough was to make sure that the things that were in that pencil copy were actually in place.
In construction, a walkthrough is where you're just looking at to say, this is percentage of work, looks apparently as if it's complete. But we reserve, in the contract, specific language is that the owner reserves the right. If you pay it, doesn't mean you accept it. And you always reserve the right to go back and to be able to withhold money for payments where there are issues concerning, as there were here. They overbilled. There was a late project. This project was supposed to be done in September 2018. It ended up going until June of 2019. And there's one final point I want to make. Then the punch list had 3,500 items on it. The punch list is something at the end of a project that they promised in their manual, right, to complete in 30 days. In a contract, we gave them 60 days. They were still billing in July of 2020. In fact, they demobilized in January of 2020, but yet they billed in February and March. They started the lawsuit in March of 2020. They continued to bill in April, May, June, July. And that's why if you look at this and you study this, in the beginning, before we got an idea on how late they were going to be, the first 16 were paid in full. And then we started to see some of the problems, including a problem where in 512 rooms, they missed an 120, 110, 120 volume dampers. This is why we have an allegation for negligence. That just shouldn't happen. And this, again, and then
all this was within the scope of their work. All this was within the scope of their work.
All within the scope of their work.
So it's not as they allege that it was not within the scope of their work, but it was within the scope of Summer Flight's own contractors.
No, our own contractors came on at the end of the project to finish the project because they never finished the punch list, and because they couldn't get the elevators working, and because they couldn't get the cogeneration facility. But one last point I want to make, even when it was the COVID shutdown, March of 2020, city shuts down. They billed in March, April, May, June, and July. They billed us. In fact, you talk about the value of the monies, $10 million they billed us during that period of time in what they said was direct scope, and $4 million in general conditions. That is close to a 40%. No one in this city, not a contractor, gets that rate for their general conditions.
You have time on rebuttal.
Thank you.
Okay, there was no fixed completion date in the contract. Unexcused late completion, even if proven, is not actionable. Liquidated damage provision is not applicable to this project. The relevant contract provisions are 3.4, 6.3, and 6.12. There's no GMP amendment, there's no GMP schedule, there's no substantial completion date, and there's no time of the essence and no liabilities for LDs. Flight Center is not making a claim for any kind of identified damages as a result of Turner's managing the project, managing the schedule of the project. The only claim they're making related to delays is for liquidated damages, and there cannot be liquidated damages unless there was a GMP schedule. They chose not to have a GMP. And as the court, as Your Honor, you pointed out, 3.1.8 provided that Turner does not guarantee the schedule. Now, the confusion is created by the trial court's opinion, which talks about, well, the contract contemplated a 24-month construction period, and this did not occur. That observation is irrelevant to the claim they're making. The claim they're making is for the liquidated damages, not just some other types of damages associated with delay. So that should be out of this case completely. Counsel mentioned 120 volume dampers. Turner performed that work. That's not the claim they're making here for completion. Those items, Turner's witnesses, their project manager and their project executive, in their affidavit, set forth for each of those items that are in the claim, the completion claim, that the work is not in Turner's scope. And if Turner had been
So it
asked...
was not within your scope of the work that you performed?
It was not part of Turner's scope of work. That's what they swore to. Flight Center hasn't produced, if you go through every one of their counterclaims, you'll see that they have not come forward with affidavits from any witnesses as to contradict the testimony, the sworn testimony of Gary McHassey, the project manager and project executive, and Janice Camarillo, who went through in detail as if this was their trial testimony. There is an absolute failure to come forward and refute any of those claims with respect to any of their counterclaims.
Thank you.
Thank you.
You would need a scorecard, unfortunately, just to take
So
the provisions that he
is-
identifies.
We're back to the GMP. Are you making a claim for liquidated damages?
Of course we're making a claim for liquidated
So then
damages.
why
Do it.
doesn't the GMP, why isn't that significant then? Why is that, why should we not?
Because you
consider
can
that?
make, because once you have a schedule and you're supposed to complete work 24 months for a construction phase, and it's expressed in the contract, then when those 24 months come and go and substantial completion is not achieved, and there's no change orders that would extend that, right? Then you're responsible and liable for the fact that you didn't timely achieve completion of the
Even though it says that it's not guaranteed unless you have a GMP amendment.
I'm sorry?
Even though the contract says that that schedule is not guaranteed unless you
The
have a
only thing the
GMP amendment.
GMP guarantees is the price. It doesn't guarantee the schedule. And with respect to what you're saying about His Honor was absolutely correct. There's an entitlement for liquidated damages. There's also an entitlement with respect to the damages that we have because they overbilled us, all right? They had a failure of there was defective work that was installed. We had to bring others on to complete the work. And you know what the interesting thing is here? Is they're trying to navigate their way into, well, we want this to apply, but this doesn't apply. So liquidated damages doesn't apply in the contract because they say so. But we're going to have the fact that there's no substantial completion date. We're going to make that one up too because it says there's a substantial completion date. We don't want to do that either. All we want to do is get paid for work that we didn't do and work that we shouldn't have got paid for. And the fact of the matter is if you look at, and just I'll leave with this last point, we paid and we continued to pay. And we even paid after this lawsuit started, and we even paid beyond them. There's trade contractors who deserve payment until they stopped us from making payments directly to trade contractors. So we paid them, I believe there was $284,000. We paid another, took off, closed out another $7 million with trade contractors after we were in a lawsuit. So it's not a problem about paying, it's just that we're not going to get overbilled and we don't want to be cheated.
Thank you. Thank you both. People v. Aaron Kish. Yes.
Shall I wait? Shall I wait for justice?
Oh, you may proceed.
Good afternoon. The Legal Aid Society by Lily Getz on behalf of Appellant. Aaron was a 17-year-old child when he was convicted of very serious offenses in this case. But the context is crucial here.
I'm sorry, was it not Aaron Kish? What did I say?
Right.
Oh, I thought you said another name, I'm sorry.
He had survived years of sexual violence perpetrated by his father, beginning when he was a toddler. He is developmentally delayed and was wearing diapers from the age of 10. He had no prior criminal convictions, and he later accepted full responsibility for his conduct in this case, pleading to the
I
entire
thought this was
indictment.
his second sexual assault.
That's not true,
He did not have a prior?
No. This is his first criminal conviction of any kind. He had a prior adjudication as a child while he was in New Jersey for what would constitute in New York State misdemeanor criminal mischief. There was absolutely no sexual component to that. Adjudicating Aaron a youthful offender is a just outcome here because of the constellation of factors.
So there was no attempted sexual assault in New Jersey, at New Jersey Mentors assaulting a staff member?
There were some allegations in the prosecution's papers regarding disciplinary issues that he had as a child when he was being held at one of the many institutions.
And a prior conviction in New Jersey for CPW 3?
He has no prior convictions. That isn't.
I'm sorry, I assume he's a JO or YO, but he did not have a prior adjudication for criminal possession of a weapon in the 3rd degree?
He was never adjudicated anything in adult court. He had a family court prosecution that
He had a
ended
JO. There was a prior
juvenile delinquency adjudication.
right. I apologize. So juvenile delinquency adjudication for CPW 3.
I don't know what the term is in New Jersey, but the conduct that he's alleged to have and been adjudicated for committing was scratching a car with a key. So that is certainly problematic behavior.
Okay.
That is teenage.
So let's talk about this incident. What about this incident where he follows the young lady into the vestibule of her building, chokehold, and then sexually abuses her?
Nothing I'm saying here today, Judge, is intended to undermine the absolutely serious nature of the allegations and of the accusation that he pleaded guilty to. But the fact remains, this court must consider the constellation of factors about his life as the context for what happened on that day. Again, nothing I'm saying minimizes the seriousness of the offense and the result to the complainant, the injuries she suffered, the harm she suffered. Nothing I'm saying changes that. But the fact is, this is an experienced bench. We've all seen many arguments for youthful offender treatment and for sentence reductions. This has to be among the most profoundly disturbing record of a young person's upbringing that I would postulate has ever appeared before this court.
So the judge in this matter specifically stated why she was not conferring youthful offender status, and she gave the reasons why she was not conferring youthful offender status, all based upon the record and based upon your client's prior history, upbringing, et cetera. So why should we now impose youthful offender status, confer youthful offender status, and why should we then now go against the judge and not accept her determinations as to youthful offender status?
So I think I'm hearing you ask whether she abused her discretion and whether this court should disturb her finding in this case. And
we would have to, right? We would have to find that in order to...
You absolutely don't have to find it. This court has jurisdiction to assess the facts in the case fresh and to determine that justice would be served by either a youthful offender adjudication or a second request.
I guess my question was, and I didn't pose it, I wasn't clear. Given the fact that she sat on this case and firsthand saw the defendant, spoke to defense attorney, prosecutors, reviewed the record, et cetera, and why should we now overturn her determination or make a determination other than what she made when we're just kind of looking at a cold record?
Well, because, Judge, this is a unique situation where the cold record here is rich with profound examples of the victimization and trauma that Aaron suffered as a child in this case. There's a 31-page pre-pleading memorandum in this case which elaborates all the details of what he suffered. For example, his father, when he was 4 years old, taped his entire body onto a bed with duct tape in order to restrain him. When he was 4 years old, his father began raping him in the bathtub. This is a young man who, when he was a 17-year-old child and committed the offenses in this case, had survived already so much. This
And so
evidence
was
was
any of this information not before the sentencing judge? Did she not also have access to and read the she was presented with the pre-sentencing report, the same 31-page report?
Absolutely, Judge. But this court has the discretion and the power, the unique statutory authority to ensure that appellate records, that appellate judgments serve the interest of justice. That is your burden in each case where an appellant comes before you and says, you should grant youthful offender treatment on appeal in this case. Every time the court is asked to consider this kind of an argument, you must, in fact, just look at the record again. And our position, and I think we're fully supported by the evidence in this case, is that this is a powerful set of facts that strongly militate.
And so what is it? The defendant was sentenced to 9 years he pled guilty to the attempted murder in the second degree. He was sentenced to 9 years plus 5 years post-release supervision. What is it that you're requesting?
So we're requesting either an adjudication as a youthful offender, which the impact would be that he'd be permitted to re-enter society without the onus of a criminal record, which would enable him to more freely take advantage of the resources that we know he needs, the supportive services that he needs, that having a criminal record are going to infringe upon. The alternate request that we've made in our papers is for the court to give a modest sentence reduction. He has already served 8 years of this case, the sentence in this case. He was 17 years old at the time. He's now 25. If the court reduces his sentence by even 1 year, it would really have an impact on him, and it would allow him to re-enter society more quickly. Every day that he spends in state prison is torture. At this point in time, when given the circumstances that we're in right now, the Department of Corrections is in right now, there's no penological purpose served by continuing to hold him in custody when he could be released. He desperately needs services that the Department of Corrections is simply not in a position to provide him with, cannot provide him with, and support that he needs given his unique circumstances, his traumatic upbringing, his developmental delays, his long untreated mental illness, and the fact that he has accepted responsibility for the entire indictment's charges. For all of those reasons, judges, we ask that you either adjudicate him a youthful offender or reduce his sentence in the interest of justice.
Thank you. Yes.
Good afternoon, ADA Phelps for the people. The defendant should not be granted youthful offender treatment for the attempted rape and murder because of the seriousness of his conviction, the fact that he has had 9 years of treatment that has not successfully worked before he committed this crime, and because of his long history of sexually acting out. The factors the defendant argues today as reasons why he should be granted youthful offender treatment were brought up before the court on sentencing, and they considered them carefully before giving him the sentence they did, including rejecting youthful offender status.
Did people originally request 15 years?
The people did originally request 15 years, which is 6 less than defendant was granted. If this court does grant youthful offender status, not only will he not be granted a criminal conviction and will he be released a year early, but he will not be required to register for SORA. This is especially disturbing in this case because the psychosexual evaluation that he was put under by psychologists found that he was at a moderate high to high risk of reoffending. Defendant should also not be granted a lower sentence in the interest of justice because of the 9 years, of treatment that has not worked from previously. This includes therapy to address not only his aggressive behavior, but his inappropriate sexual behavior. The fact that he's been given a sentence 6 years below what the people recommended and 16 years below the max, and the extreme gravity of the crime this committed. This was an attempted rape and murder of a stranger.
So he was sentenced to 9 years in 2019. Isn't he up for parole already?
He has 1 year left. He served 8 of the 9 years.
He served 8.
Again, the factors that the defendant is arguing today, including the motion they reference, was before the sentencing court, and the court explicitly on the record talks about the factors, including his horrible history, which the people do admit is very graphic and very sad. But they balance that against the serious harm that he's committed when they give him the sentence, which again is 16 years below the maximum. So that was taken into consideration. They're giving the sentence, and we argue it
This
is
was
not.
basically his first arrest, right?
This was his first arrest. He had a criminal possession of a weapon in New Jersey, but that wasn't a sexual, as we talked about before, although it was not taking a key and scratching cars. His defense argues he stole a knife from a restaurant, no scratching cars. That's why it's possession of a weapon. But he does have a long history of sexually acting out. As talked about, he groped a staff worker without consent, a New Jersey mentor, and that's why he was kicked out of that program. He's also admitted to having rape fantasies to clinicians. He's previously claimed to raped 2 other women, and though the police did not find any evidence that that actually happened, it shows a disturbing pattern of thought. And he has also said that he sexually assaulted another woman, though not raped her. And again, police did not find any evidence of that, but it shows his thought pattern, like what he...
So you're saying he's fantasizing about
He
doing
is
these?
fantasizing about committing these crimes, correct. And he has like a long history of doing like groping the mentor, or for example, in another placement program, he had issues with the program because of his aggression, but also because he was standing over a naked roommate and had his penis out. So he has had a long history of sexually inappropriate behavior and has been in therapy for these issues, and that therapy has not worked.
Can you address counsel's argument that maintaining his condition as it is, not granting the YO, that's going to have an impact on his obtaining services? Because it appears as if he needs a lot of help.
We're not in charge of services, so we can't say for sure whether that would impact or would not impact his services. But presumably the services that he needs would be for sexual offenders, since this is a very serious problem. So I don't see why that would affect those services that he needs, because the mental health treatment he needs is for his sexually inappropriate behavior, along with his aggression. We would also like to address the fact that in the reply brief, defendant says that we cite outside the record when we reference his criminal history in New Jersey. However, a defendant's criminal history is always part of the record on appeals, so his criminal record in New Jersey is part of the record.
Thank you.
Thank you.
Just to be clear, because words matter, he has no criminal record in New Jersey. He was prosecuted in family court as a child, and he was
He
adjudicated.
has no criminal history whatsoever.
Correct, before this case. Thank you. The prosecution argues sort of in isolation each of the facts about about Aaron's life that prevent what they believe would be an injustice if the court adjudicated him a youthful offender. But really, this is a serious case, and in cases like this, this court and trial courts are equally empowered to grant youthful offender treatment, even if this is a serious matter, and it is.
What about the argument or statement by your friend that if we were to grant youthful offender status, that therefore that would obviate, there would be no SORA registration?
That's correct. Youthful offender treatment would relieve him of both a criminal conviction and the SORA adjudication that would flow.
So given
only
his
from a criminal
history, should there not, and also given, I think there was something in the record about his risk of reoffending, is that not what SORA is all about in terms of his registration? Should that not be a requirement?
Well, the reason SORA doesn't apply to youthful offenders and to juveniles prosecuted in family court is based on the understanding that children are malleable, that when somebody commits offenses of any kind, behaviors of any kind as a child, the likelihood of reoffending, of recommitting those behaviors as an adult dramatically shifts because their brain is not fully formed.
But has he not exhibited behavior and tendencies which would lead one to believe, and as stated the experts in this case, that he will reoffend and that he may in fact act out in terms of abusing or attempting to abuse other individuals?
There are records in the case, evaluations by some clinicians and not by others, indicating that that those individuals believe that he has a likelihood of reoffending. That's in the record. If the court is not inclined to grant youthful offender treatment on that ground, then a modest reduction in sentence is appropriate here, given the gravity of this case, balanced with the incredible constellation of factors about Aaron about his life, about who he is as a person and who he was as a 17-year-old child wearing diapers who had the developmental age of somebody far, far younger.
But did the court already take that into consideration when it sentenced him, offered and then sentenced him to 9 years, which is 6 years less than the minimum?
Indeed, the court did seem to recognize more than the prosecution did what impact this large collection of mitigating evidence had in terms of mitigating his responsibility. But the fact remains, Judge, that this is an attempted murder where there was no physical injury. There's no assault charge here, okay? The minimum for attempted murder is 5 years. The minimum for an attempted rape, which is what this was charged as, there's no completed rape here. There's no semen. There's no saliva anywhere on the complainant's body.
Did he not?
He admitted to this, but
And in fact, did he say he was going to kill her, but then for whatever reason he decided not to kill her, but rather he was going to rape her?
so these statements, Judge, are very disturbing. These are statements to the police by a small 17-year-old child who has been victimized for nearly his entire life.
We have video, there's video surveillance as well, right? Was there not a video?
There's references to video surveillance. That was never provided.
But we do have the victim, who was a stranger, who was followed into the vestibule of her building.
Absolutely. Right? And nothing I'm saying, again, undermines the seriousness of that fact. But the point is, this is a relatively small 17-year-old child who is just 5'6", nearly 8 inches shorter than I am, who came into police custody after EMS discovered him aimlessly walking on the street and took him to the hospital as an unaccompanied minor. This is a young, small person, and the statements he made to police should be viewed in that context. Somebody who was subject.
So small people can't kill and rape, right?
That's not what I'm saying.
I don't know the size of the victim. But again, we have the record. We will obviously continue to review it and make a determination. Thank you both. NYP Holdings versus the New York City Department of Social Services.
May it please the court, Jeremy Schwader for the Department of Social Services and Department of Homeless Services. This is a straightforward case of statutory interpretation. Social Services Law 136 bars publication of the names or addresses of persons applying for or receiving public assistance and care. This means it's a violation to publish the names of such people.
Well, these are individuals who are in a shelter, so do we know necessarily that they are receiving public funds?
If they're in a shelter, they're receiving public assistance.
So they would, public assistance, so they would fall under the rubric of the statute?
That is correct.
Okay.
That is correct. So they are receiving public assistance. I think that petitioner argued below that the addresses and names had to be tied together. I think the petitioner has moved away from that interpretation of 136 on appeal. Petitioner now just says, well, it only applies in some circumstances, but the statute is categorical. It's a very simple, straightforward reading that we're asking for. We're really asking for the natural and plain reading of the statute.
But there was also an argument that because this, it was transitory, temporary residence, and therefore it should not, there should be some type of an exception or the information should be turned over.
That was Supreme Court's ruling. Supreme Court did not subscribe to petitioner's understanding of the statute. Petitioner said, well, shelters aren't really addresses under the statute because people only live there for a temporary period of time. That's not correct as the common understanding of what address means. It's also not correct factually on what the record was in front of the court, which showed that at the time, in fiscal year 22, which was the time period that we had, people were living there 500 days or longer, so that's no temporary period.
And they were also receiving mail and other communications there.
They can. And that is what, when you're using the common definition of address, which we cited to Black's Law Dictionary, which says a place where mail can be sent and received, the regulations of the state make that a right for people living in statutes. So there's no reason to look beyond the common understanding of address. And then there's the common sense understanding of address, which is people going to homeless shelters have no other place to be. There is no other address. So this idea that petitioners have brought up on appeal that DSS has to go out and prove that there's not another place where maybe they're receiving mail. Well, that's not really the case when you're talking about people going to shelters. People are not eligible to be in homeless shelters if they have another place to live. This is their address while they're there.
What about the argument that you have that DSS has disclosed this information in other contexts?
We absolutely acknowledge that DSS has done so. We have explained the reasons that it's happened, but it was mistakes. We can say that now. And DSS has taken steps to make sure that those mistakes don't occur again. I would say that third parties who are intended to be protected by the statute shouldn't suffer because of DSS's mistakes. Certainly there's no estoppel being claimed here because of those mistakes. And I would also say that the mistakes that were made, which we have explained why they happened because of laws that require certain disclosures when there's procurements and so forth, are very different than a newspaper coming in and saying, well, we want to publish the addresses of every single shelter that are out there, a widespread newspaper. I think that the purpose, if you look to the purpose of 136, it is to prevent the exploitation, the embarrassment, the loss of dignity of people who are receiving public services.
Is some of this information, if not all, available in out there in the public?
No.
Like the internet, or is not?
I mean, I think that somebody who was attempting to find certain addresses could probably find certain addresses, right? So, I mean, there have been mistaken disclosures, absolutely. So, but that's very different than saying, don't worry about 136, give us a list of every single shelter out there, when we have a statute that's very clear. Now, why those other disclosures happen for various other reasons, I can't explain.
So
I can explain.
I can't do a Google search and find every single address of every shelter in New York City?
I don't believe you'd be able to say, what are the addresses of New York City shelters, and find the addresses. Now, what DSS does make public is public information where you can find other location information. You can find the borough. You can find the community board district. And that's important because in other cases that have been in front of this court involving FOIL, this court has said that specific addresses of where people live don't really go to the purpose of FOIL. But especially when there's other similar location information that's available. And I know that my colleague here has said, well, this is important, and if you don't give it to us, what you're doing is blocking oversight of the shelter program. We have invited petitioners here to explain how they are blocked from doing oversight of the shelter program by getting the specific addresses under the exception for news organizations, which we have offered to provide them. With that, they can do whatever investigation they need to do. But we have not heard anything about why publication of those specific addresses is so important.
Did the legislature already have a battle with this devil in 1953 and 1960? Did it consider this very point, the extent to which the news media should have access to these records?
It did, and it provided this very balanced compromise solution, which says news media can get access to this information if they sign a protective order. And what DSS did here and said, we're going to give you the information, sign the protective order, and you can have it. And what petitioners here says, no, we are not signing that protective order. You're not entitled to 136 doesn't apply here, so we don't need to do so. We have always offered to give them this information under the protective order that the legislature carefully crafted to allow for the kind of oversight that petitioners say they want to do, but also to protect people receiving public benefits.
Thank you.
Good afternoon, Your Honors. May it please the court. Jeremy Chase from Davis Wright Tremaine.
So why not avail yourself of the exception in terms of media?
In terms of the news gathering exception?
News gathering.
There are a number of reasons, Your Honor. First of all, we do not believe that Section 136 applies to the addresses of homeless shelters. That's number one, which I will get to, Your Honor. But more importantly, the agreement that they presented us with not only would prevent us from disclosing the particular information provided by DHS, but it would also prevent us from reporting on any addresses, regardless of whether or not any addresses of homeless shelters, regardless of whether or not we received it from DHS. It's incredibly broadly worded, and it's simply just.
What's the purpose of obtaining this information?
Well, Your Honor, first of all, the purpose of this interpretation is so that we can report on the conditions of the homeless shelters, for one. Two, so we can see that these homeless shelters are equally and evenly distributed around the city, as the last two mayoral administrations have promised to do, and also so we can make sure, as the public, that that these homeless shelters are being kept up in the way that they're required to under the consent decree.
So why do you need the addresses for that?
Well, for example, the addresses, we could check those addresses against the building department records, for example, to make sure that there aren't any housing violations, such as, no fire alarms or decrepit conditions.
So you can do that, okay? They give you the information, let's say through that protective order, and then you go and you see for yourself, and you can publish all you want except for the address.
Well, except for, Your Honor, that protective order first of all, that protective order that they provided us with would prevent us from reporting the addresses if there was a crime at a homeless shelter.
But that's the whole thing. I mean, why there's a crime at a homeless shelter?
Yes.
Right? Or there's a homeless shelter that is dilapidated, and that's what you're interested in.
Yes.
So why is it that you need to publish the address, the specific address?
This is part of what the Post does all the time, what every newspaper does all the time. If there's a crime at a...
So you don't publish where there's a crime at a homeless shelter? Because I thought I've seen this in the newspaper, that there was a crime at something occurred at a homeless shelter.
Correct, Your Honor. That's what I just said, that if there's a crime at a homeless shelter, we'll provide which shelter it's at.
Yeah, exactly.
Yeah, exactly. But if we sign this agreement, we'd be prevented from doing that, and we'd be admitting.
No, it says, what it says is, shall give assurances in writing that it will not publicly disclose or participate or acquiesce in the public disclosure of the names and addresses of applicants for and recipients of public assistance and care.
Correct, and I'm referring to the specific agreement that was presented to us by the DHS, which says, I will not, nor will the firm or organization I represent, publicly disclose or participate or acquiesce in the public disclosure of PA, which is just the names or addresses. Regardless, it doesn't specify that it's with respect to what's provided specifically from the government. But
that seems to mirror what I just read in terms of the statute.
It does, but it doesn't specify that if we learn it from some other source, such as walking down the street and seeing a homeless.
Well, I was going to say, if you walk down the street in New York, you would know where is a homeless shelter. Or you ask anyone on a block, where's the homeless shelter?
Or Your Honor,
they will tell you where it is. So I'm not understanding
exactly
what the issue is. And my colleague mentioned, in response to you're speaking of building code violations. You could do it the opposite way. You could check to see which buildings have a violation and then check to see whether that's a homeless shelter. So again, I don't understand how you're precluded in any way from amassing the information that you're attempting to amass.
Well, Your Honor, I think the key point here, you're kind of hitting on something here that I think is really key. The DHS routinely has disclosed this information to the public. And for them to say that it's a mistake that they've done it is absurd. It's in any competitive bid.
They have to by law with procurement.
And FOIL is also a law, Your Honor.
But this is also the law.
Sure, but there's no exception in the law for procurement in Section 136.
But this is sort of a statute of general applicability, and then there are special statutes that will supersede. So procurement would be one.
Sure.
But what force and effect does this have, particularly in light of the 1960 amendment, where the legislature considered this balance of to what extent do we want to honor the press and the public's right to be informed about the situation with respect to public assistance on the one hand, and our privacy concerns on the other? They balanced that in 1960, and this is what they came up with. So what would be left of this if we agree with your interpretation?
Well, Your Honor, I think that the key point here is that the particular address has to be tied to an individual. And the fact of the matter is...
And so that's the textual argument then?
Yes, it's the textual argument and it's the rational argument. Shelters are simply different than the addresses of shelters have to be considered differently because they're the benefit themselves. This is different than SNAP or cash assistance, where a check is mailed to an individual and they receive that at their address. And the records.
Why?
What's that?
Why?
Why is it different?
Why are they not to be accorded the same sense of privacy?
Well, first of all, the idea that people stay at these. May I continue, Your Honor?
Please.
So, first of all, DHS routinely discloses these addresses per procurement or through their
Mistake, whatever, for a variety of reasons.
For the last 5 years through their annual plan. This is no mistake, but they would never disclose the addresses of a recipient of SNAP benefits, for example, because there's no purpose to do so. It's simply a different category of record. The addresses of a shelter are not the permanent addresses of an individual. And the idea, I just want to correct one thing that my adversary said, which was that people stay in these shelters for an extended period. That's not what the record says. The record says that they stay in the shelter system for an extended period. There's no evidence in the record that people are at one particular shelter for an extended period of time. So I just want to make that clear. If there's
the legislature wanted to limit 136 to the recipients of certain types of social service benefits, why didn't it specify that?
They did, Your Honor. If you look at Section 2, subsection 18 of the Social Services Law, it specifically defines what public assistance and care is, which includes family assistance, safety net assistance, veteran assistance, medical assistance for needy persons, institutional care for adults, and child care granted at the public expense pursuant in this chapter. That's the definition of public assistance and care, which is the term that's specifically in that statute. Nowhere does it say homeless shelters.
Well, it seems to me that that's what a homeless shelter is all about, and that's what people are receiving those benefits at the homeless shelter.
They may well be receiving other benefits there, but the homeless shelters themselves are not the benefits.
It is the benefit.
Well, they're not.
Are they paying rent at the homeless shelter?
Let me clarify.
Why would it not? I'm not understanding. Why would it not be a benefit? Are they paying any type of rent at the homeless shelter?
No, Your Honor, but to clarify what I just said, homeless shelters certainly are public benefits, but they're not public assistance and care as defined in the statute, which is what is the term that covers Section 136. And to be clear, each of these other itemized types of assistance, family assistance is cash assistance to eligible needy families.
Family assistance. There are families who reside at the homeless shelter.
I'm sorry.
There are families who reside at the homeless shelters.
Absolutely, Your Honor.
So why does that not constitute family assistance?
Well, Your Honor, we're not saying that it doesn't fit within that definition. We're saying that it is the burden of the government to make sure that the exemption that they're asserting, that the material requested falls squarely within the ambit of the statutory exemption. They've never said in the record that this constitutes public assistance and care under Section 136. The closest they came is to say that in paragraph 42 of their answer, that homeless shelters' addresses must be confidential to comply with the spirit of the law. There's nothing in their answer that overtly says that it constitutes public assistance and care as defined in the statute.
Thank you.
Thank you.
First thing, let me respond to this last argument, which is the very first time I have ever heard this throughout the entirety of this case.
Well, in fairness to him, it was prompted by something I asked him, so.
But he came prepared to make this argument that we've never heard before. And if the court is interested in that, I would ask for additional briefing so we can discuss this on a statute that's never been brought up in this case before.
It just seemed to me it just made sense. I just always assumed that a homeless shelter, individuals living in a homeless shelter receiving public assistance.
And they have proceeded under that understanding throughout this case and never said anything otherwise until this very moment. And I'm not even sure that's exactly what he's saying now. But if the court wants to pursue this further, I would ask for some additional briefing on this. But I think what he's really asking for is for this court to find an unwritten exception to 136 for shelter services, which obviously does not exist in the very plain and simple and straightforward language of the statute, which has been amended many times over the years, but not that part of the statute. That has not been amended.
That traces back to like 1929, the public welfare
1940.
law.
I think it's 1940 is when 136 came in.
Is this statute clear and unambiguous? And are these families using this address for their medical records, their school records, their employment records, the address that they're living in?
They're certainly entitled to. The law makes that, and they are entitled to do that. They have no other address to use if they are in the shelter system, because that is the eligibility for being in the shelter system, is that you have no other address. So Supreme Court really misunderstood, for reasons that were not clear based on the record, based on the common understanding of the word address, I think took that word to a whole nother place.
Do we draw a distinction between shelter system and shelter? Because I believe your friend mentioned also that you stated that they were in the shelter for X period of time. And what you meant was, or what DSS meant was shelter system.
Well, this was actually information that petitioners put in the record. This was not our information. Those numbers come from petitioners' documents that they put in the record. So yes, it was shelter system, shelter, it doesn't matter. You're still getting public services. You're still entitled. That is your address for the time that you're there.
But
so,
you're indifferent. If you're in the system, meaning that you move from one place to another, you wouldn't be at the same place all the time, right? So then how could that be your address if you're moving from one particular shelter to another shelter?
Well, I don't know the details of exactly how often people move, right? So we're really kind of speculating about things that we don't know. But that's just like anybody moves. If you're looking to get mail, you tell people your new address. I mean, it's no different. That's certainly the definition of address.
Your argument is that there's no difference if you're in one particular shelter on West 23rd Street for 40 days, and then you move to West 24th Street for another 60 days or something of that nature.
Certainly no difference. Certainly no difference when it comes to thinking about what 136 is trying to protect, which is their dignity for people receiving these types of public services. None of that matters.
Thank you. Structure tone v. Merchants Preferred. Yes, you may proceed.
May it please the court, Kate McGuire-Tedrick for Appellant Old Republic. This insurance coverage action hinges on whether or not this court believes that the court determined in the underlying related action of Scott Cackett versus Structure Tone, whether or not third-party defendant Port Morris was found negligent in that action. At the court level of that action, all claims were dismissed against Port Morris, and there were 4 causes of action against Port Morris. One of them was common law negligence, and it was asserted by Structure Tone, who's the respondent herein. At the appellate level, they did not dispute, and they did not seek to overturn, Structure Tone that is, did not seek to overturn the court's decision regarding negligence. Instead, they only brought up contractual indemnity. And the contractual indemnity portion of that decision in the related Cackett action was overturned. And the court itself said that there was a need for trial solely because Structure Tone cannot be indemnified for their own negligence. So they stated in that decision that Port Morris was not negligent. They found that the contract between Port Morris and Structure Tone required Port Morris to provide indemnity because of the language arising out of. Now, what we're dealing with here is the insurance coverage action, where Structure Tone is seeking to be an additional insured under a policy issued to Port Morris. In that policy, it's the language caused by. Now, caused by the acts or omissions of the named insured under Burlington back in 2017 changed the law in this area. And it determined that arising out of is not the same as caused by. And for caused by, you need proximate causation. Proximate causation cannot be had without negligence. So because the court in the related action has already determined that Port Morris is not negligent, there cannot be any determination that the actions were caused by the acts of Port Morris. Now, Structure Tone is attempting to argue that Scott Cackett's own personal negligence in walking into an unlit room and having a door fall on him, none of which was part of his job as Port Morris, that his own negligence can be impugned upon Port Morris. In the insurance
The determination as to Port Morris not being negligent, was that not in the context of the workers' comp?
It was in the context of workers' comp, but in addition, it was also discussed regarding the indemnity itself, and both the lower court and this court found that there was no negligence, and they didn't discuss that in the terms of workers' comp. It was discussed in terms of they were talking about the contractual indemnity clause and whether or not there was any negligence and whether it was arise by versus caused by. And they found because it was arising out of in that contract, it was a higher standard. So therefore, Port Morris must indemnify Structure Tone for any liability caused by any other party other than Structure Tone.
So there was a clear finding that Port Morris was not negligent?
Yes. By both.
Because I thought that it was clear, it was only in the context of workers' comp, and there was no determination on its face that Port Morris was not negligent.
There was a determination on its face in the record of that underlying action. All of the information and all of the evidence was brought before the court regarding this, and the court stated that they were not negligent. And they didn't state it solely in terms of the law regarding workers' compensation. That was not when it was stated. It was stated with regard to indemnity and whether or not arising out of was the same as negligence. There's one case that's actually very similar to ours, which is Live Nation Marketing versus Greenwich Insurance Company. And in that case, it was actually an employee for Best Buy who was putting up an advertisement at Jones Beach Theater. And he was an employee of Best Buy, and a crane owned by another contractor fell on him, similar to a door falling on somebody here. And it fell on him, and this court determined that, that Best Buy was not negligent because it was not caused by, and there was no negligence found as to Best Buy in the underlying action. Moreover, they then stated that because the individual was working for Best Buy and Best Buy wasn't negligent, it also necessarily flows that the individual also was not negligent because Best Buy wasn't negligent. In addition, the request that they're asking to find that the contributory negligence can be impugned based on Scott Cackett's activity has never been done. They didn't cite to a single case wherein, especially after Burlington, wherein an employer was found denied summary judgment because the actual injured party could have been contributorily negligent. This hasn't happened yet. So what they're asking is to create a new area of law on this. And so far, all the cases—
Can a plaintiff be a proximate cause of the plaintiff's injuries?
Because of the labor law and the underlying action, they cannot be liable statutorily.
Well, under 240 sub 1, they couldn't.
Yeah.
But 241 sub 6, 200 common law negligence, there can be, Burlington says there can be more than one proximate cause. I guess what makes this different is now it's the plaintiff's negligence we're looking at as opposed to a co-defendant or a non-party.
That's correct.
Okay.
And
So we said there's no evidence that any negligence on Port Morris's part contributed to plaintiff's accident. Its duty to indemnify under the agreement was triggered by the fact that the accident arose from plaintiff's performance of his work as an employee of Port Morris.
Yes. But arose out of is not the same as caused by. So to determine that that therefore means caused by, it's contradicting Burlington, and it's contradicting all that progeny over the last 8 or 9 years.
We also said that there was an issue of fact as to whether KD and Interstate proximately caused the accident.
Exactly. And the issue here is, and this was briefly mentioned in the brief, the underlying action has been settled. It was settled by Structure Tone years ago. where they've already paid, and this is a pay and chase. They're coming after us to get additional coverage. So they're coming after us, but they're not coming after Interstate, which is the main wrongdoer here. Instead, they're coming after Port Morris, and they're coming after Katy Electric. And so they're trying to get a percentage because under the determination in the underlying action. And again, this is regarding the indemnity clause in Port Morris's contract, but unfortunately for Port Morris, if Interstate is found 50% liable, if they don't go after Interstate, technically Port Morris has to pay that because of their indemnity clause. That doesn't mean that Old Republic, with their caused by language, has to pay that.
You have time. You have time on rebuttal.
Thank you.
May it please the court, Thomas Dillon for plaintiff respondent structure tone. I think the key issue on this is whether collateral estoppel can be applied in the declaratory judgment action, and it clearly cannot. There is not an identity of issues in this case, and while the appellants want to, among other things, try to say that the dismissal on the grave injury threshold on the third-party claims against Port Morris somehow involves plaintiff's own conduct, it simply does not. In fact, plaintiff's conduct has never, ever been decided. It's never been briefed. And quite frankly, when you write an AI form that says there is additional insured coverage for the actual omissions of the named insured or those acting on its behalf, you open up the door to allow an argument that plaintiff, who was clearly acting on Port Morris's behalf, is one of those people that if those accident or omission did cause the injury, then that should be, at a minimum, a question of fact for the jury to decide in this case. I don't have anything else to say in regard to the collateral estoppel argument unless there are questions from the bench.
Thank you.
Thank you.
May it please the court, Paul Hoansky for respondent merchants. My colleague, Mr. Dillon, really did hit on the salient point as to why merchants, and merchants does share the same points as to why Old Republic's summary judgment motion was properly denied. There's no collateral estoppel here. It is apples and oranges. The court below addressed the contractual indemnity. The only claim before this court in the underlying action was the contractual indemnification claim as against Port Morris. And while there's some cherry picking of language about negligence, this court in the very same sentence says negligence has nothing to do with whether or not the contractual indemnity, it has nothing to do with whether the indemnity clause is triggered or not.
Because we never made a determination as to whether the plaintiff was the proximate cause of his accident. There was no determination as to that. We don't know. He's an employee of Port Morris. So therefore, you know, again, if he was the proximate cause, that would bring Port Morris back in the case, right? Port Morris, I think there was also testimony concerning their responsibilities as to the lighting conditions, if I'm not mistaken.
Well, it's responsibilities for keeping a safe
yeah.
working area, which that closet was the plaintiff's working area at the time. So again, unless the court has any questions of me, I'll rest on the brief.
Thank you.
Thank you.
Good afternoon. My name is Ann Odelson, and I represent Scottsdale, and my argument is really, really simple. Scottsdale issued an excess policy to Interstate. So there's a primary policy, and then there's a Scottsdale excess policy. Old Republic asserted cross claims against Scottsdale. Structure Tone discontinued the action with prejudice against Scottsdale and also discontinued the underlying action with prejudice against Interstate. So the cross claims against us are moot for contribution, but also, as the lower court correctly found, you have two different levels of insurance.
You're the excess, right?
I'm the excess. This is the primary. So we're insuring different risks at different levels. So there is no right of contribution. So the lower court's ruling, as found by this court, the Court of Appeals, it should stand.
Thank you.
Your Honors, I just wanted to correct one thing that was stated regarding Port Morris did not have an obligation for the lighting. That was Katie Electric, which is actually Merchant.
No, but Port Morris had an obligation. I think the foreman testified that Port Morris was responsible for ensuring proper lighting and safety for its employees.
Well,
Did the
not-
foreman not testify to that?
I don't believe so, but the lighting itself was by Katie Electric. Port Morris had absolutely nothing to do with lighting. They were a tile
Ensuring proper
installer.
lighting?
100% correct that Port Morris was a tile installer subcontractor. They did not get involved with lighting.
But regardless, there was no determination, there still could be a determination that the plaintiff was the proximate cause of his injuries, right?
According to the language in prior cases before this court, the answer to that would be no. Additionally, just to respond to Merchant's argument, Merchants does not have any cross claims against Old Republic, nor does Old Republic have any cross claims against Merchants. So their arguments should not even be heard by this court. It's improper that they even put papers in because they have zero interest in the decision and outcome for Old Republic since there are no claims. And additionally, Structure Tone stated that collateral estoppel does not apply, and I do not understand how Structure Tone, who is the party who asserted a common law negligence cause of action against Port Morris and then went through summary judgment and then went through appeal on the issue, can now say that they cannot be collaterally estopped, which is also contradictory to their final argument in their opposition where they said, please hold. In the alternative, they said, please hold until there's a trial of the underlying decision and a potential distribution of liability among the parties in the underlying action.
I have that Judge Joseph Cuzzi, C-U-Z-Z-I, testified that Port Morris had responsibility to ensure proper lighting and safety for CACIT.
Your Honor, I can't say anything other than that's simply not correct, and that's not what the court had found previously when they found that there was no negligence. And the negligence...
I have it at record 869 to 71.
Okay, well, the negligence was not appealed to the First Department because they didn't appeal that portion of the decision. So it wasn't before the First Department, it was before the underlying court, the Supreme Court, and they found that there was no negligence, regardless of what was stated.
Thank you all. People v. Clinton Fuller.
Good afternoon. Legal Aid Society by Everett Hopkins for Mr. Fuller. Your Honors, the maximum sentence of 3.5 to 7 years is excessive here in light of the fact that most of the DNA that was found on the gun did not belong to Mr. Fuller, as well as most of his criminal history is nonviolent offenses. Additionally, the waiver wasn't
Was this the
valid
one
here.
where he admitted that where he stated that the gun was his?
That's correct, Your Honor. Yes, he did.
And was he a predicate?
Yes, he was.
For?
Nonviolent.
It wasn't a prior gun possession?
Yes, but it was a nonviolent criminal possession of a weapon in the 3rd degree attempt.
So as a threshold matter, what was the issue, deficiencies with the waiver?
So the waiver, Your Honors, I'll go to that first. I think there's no argument here that there's two issues, really, that I think we can all agree on, that the court had failed to discuss the waiver with Mr. Fuller before he had pled guilty. Additionally, the court did not review the waiver and ensure that Mr. Fuller read and understood it, the written waiver, I mean. So that alone, we believe, is sufficient for this court to find that the waiver wasn't valid. But even if it wasn't, Your Honors, the oral colloquy was here confusing. For example, the court had discussed the differences between the legality of the sentence and the excessiveness of the sentence, but never clarified which one meant what it meant. Now, us, of course, we as attorneys and judges, we know what that means, but there's no indication that Mr. Fuller understood the difference between the legality of the sentence and the excessiveness of the sentence. He can clearly challenge the legality of the sentence all the time, but when it comes to excessiveness, he's waiving that right to challenge the excessiveness of the sentence. It's not clear that he knew that. Additionally, with regards to...
Well, it says, but if you take an appeal and you are by this waiver giving up that right to have the appellate court consider most claims of error and whether the sentence I impose, which I am told is going to be 3.5 to 7, is excessive and should be modified as a result of this conviction and sentence will no longer be filed. So you're stating that the defendant did not understand what excessive meant?
And then if you continue to read, Your Honors, you'll look that the court says that he always has the right to challenge the legality.
There are a
of the
limited number of claims that survive the waiver. You can argue for example, well, it doesn't say for example. You can argue you're not competent to stand trial. I have no reason to believe that you're not. That your constitutional right to a speedy trial is violated, that your plea is involuntarily entered, that the waiver was invalid, that the sentence was illegal, or that you had received effective assistance or counsel.
Right. So he says a sentence is illegal. So that's where, there would need some clarification, because now you're telling him that he can't challenge the excessiveness of the sentence because of this waiver, but then you're saying he can always challenge the legality of the sentence. So clearly there's some ambiguity there as to whether he understands his appellate rights and what's
Is the attorney present? Is his attorney present?
His attorney was present, which brings me to the second point, Your Honors. Now, the people try to rely on the fact that his attorney had discussed the waiver with him. Now, obviously, Your Honors, this isn't, we believe it's not enough to show that the waiver was voluntary, and there's case law showing that simply having off-the-record conversations about the written waiver with an attorney is not enough to show the court that this waiver was entered voluntarily. Now, because of additionally, with regards to attorney rights, Your Honor, I think the oral colloquy, the court never clarifies that his right to an attorney that can be provided for him if he can't afford an attorney on appeal continues in spite of the waiver. Now, if you look at the colloquy, the court says that ordinarily when you take an appeal, you can still have an attorney provided for you in case you cannot afford one. Now, then when the court turns to discuss the waiver, it never discusses whether that right still attaches or not. So by all accounts, it could be that now he believes that the effect of this waiver, he's giving up that right to have an attorney present.
The court asked the defendant if before the plea was entered, he had any questions for his attorney or the court. The defendant responded no.
Yes, Your Honor, that's correct. He didn't. But the court still has a duty to make sure that it reviews the written waiver, especially when the oral colloquy is not accurate or insufficient, to ensure that as a catch-all, he understood what he signed and he read it. And the court
So
never
what
did
more
that.
should the court have done under these circumstances?
The court should have held up the waiver and said, is this your signature? Did you read this document? Do you have any questions about this document? The court never does that, Your Honor. So
That's as to the written waiver, but we still have an
Correct.
oral waiver. We don't need a written waiver as well. Is that correct?
assuming the oral colloquy is sufficient, which here it wasn't. So that's the old point.
And why, therefore, so assuming we accepted your argument that the waiver was invalid, why should we reduce the sentence to 2 to 4?
Well, I won't belabor the fact that that his DNA isn't on the gun and the fact that he wasn't observed in possession of it. But what I will highlight
Is
is
this the one where he said he fired the weapon at his girlfriend or something, his ex-girlfriend?
that's not what he said, Your Honor. What he did, first let's highlight the fact that he himself is the reason why we're here, because he did the right thing and admitted to the police that the gun was his. He gave a long statement.
It's my gun. Don't charge her. I didn't mean for it to fire. It was an accident.
Correct. So what he told the police is that he was confronted by his ex-girlfriend and multiple other people. It seems like it's confusing. It's a long statement. But he says that when they attacked him, the gun fell out of his pocket. He said that to the police, knowing that he was never
Fell
seen
out of
holding.
oh.
Right, he said that it fell out of his pocket. So he said that to the police.
What was he
knowing that-
doing in his pocket? A loaded weapon in his pocket? I'm sorry.
It was, but again, Your Honor, this shows.
Uncocked? Yeah. Cocked. It had to be cocked, right? Because it discharged. I'm not a ballistics expert, but
Well,
I seem to remember that.
We
I'm
don't
sorry,
know
go
what
ahead.
happened, Your Honor.
We were just, yeah.
That's fine. I hear you. I understand you. But at the end of the day, it fell out of his pocket. That's what he tells the police. So he did the right thing and came forward and told them, don't charge the co-defendant who was seen holding the gun. It's my gun, so don't charge her. Now, because of this, it's important to also note that the people, their own office, decided not to go forward on the violent charges.
Yeah, I didn't understand that, especially since the woman is standing over to the side and she has blood on her forehead, which is kind of weird.
Well, I don't know what happened. We can't speculate as to what happened, but what we do know is that they admitted they wouldn't be able to prove the violent conduct that was in this case.
Thank you. You have time on rebuttal.
Thank you, Judge.
The waiver.
Your Honors, and may it please the Court, Connor Glendinning on behalf of the Bronx District Attorney's Office. In this case, defendant's knowing, intelligent, and voluntary waiver of his right of appeal bars his excessive sentence claim, and that waiver is valid because, by all accounts, it tracks the model colloquy which the Court of Appeals has endorsed for synthesizing its principle in Thomas.
Well, your friend states that he was not told in terms of excessive sentence. He was not asked whether or not the written waiver, whether or not that was his signature, whether he understood prior to signing it.
Yes, Your Honor. So it's the defendant's proposition here that there's a difference between the legality argument and the excessive argument, and the defendant doesn't understand that. That appears to be somewhat of a new argument from the reply, but defendant was advised at the beginning of this colloquy that he could ask questions at any time. He was counseled. Counsel was seated next to him. He was advised that he could ask questions of the court. He said he understood.
The defendant repeatedly said that he understood after being questioned by the court, right?
That's correct, Your Honor. He repeatedly said, yes, sir, in response to, do you understand? There was no indication that he didn't understand that these were different, and they were presented by the court in separate sections, saying that he was waiving the excessiveness, but that he would retain the legality, and I think that if he had a question as to that, he would have asked it. But regardless, as to the written waiver, I think I would propose that that's valid. I don't think that Bonilla requires that they go to such extreme lengths to ask, was this your signature? Did you read this? He instructed counsel to confer with his client regarding the written waiver prior to the second call. And when they returned after the second call and he was engaged in colloquy regarding the appeal waiver, he asks, did you consult with counsel regarding this appeal waiver? And the answer was yes. So I think the court was aware that he had consulted with his client regarding this appeal waiver, and that that was sufficient here.
Is he currently incarcerated?
To my knowledge, Your Honor, he's not currently incarcerated. He was arrested on an unrelated case, but my most recent information regarding that case is that
He would have been on parole for this one, right? For this
he
case.
was on parole, and I don't have any further information regarding any parole violation.
So let's say we find this waiver to be invalid, not valid. Is the sentence excessive, given his 4 felonies and that he faced 7 to 15 on the original charge?
Yes, that's correct, Your Honor. No, his sentence is not excessive. Had he been convicted of the top count as indicted as a second felony offender, he faced up to 15 years, as you've highlighted. So his 3.5 to 7 year indeterminate sentence is not excessive here. He had an extensive criminal history. This is his 5th felony plea. The conduct itself evidences the need to protect the public, given that he was carrying a loaded weapon through the streets of the Bronx and that was discharged.
Thank you.
And we ask that you affirm.
Just briefly, Your Honors, with regards to his nonviolent criminal history, mostly nonviolent, it's worth pointing out that yes, counsel's correct. He has 5 convictions on his record.
Felony.
5, I believe it's 4 felony, 1 misdemeanor.
Oh, excuse me.
The most recent convictions, there's 2 of them. They're about 15 years old, both nonviolent. The one and only violent conviction he has on his record is over 20 years old for an
Were
attempted
these
robbery.
mitigating factors considered? Were they considered by the court with the 3.5-year sentence?
It's unclear as to whether his history was considered by the court. They don't actually go through the rap sheet.
Well, it had to have been considered by the court because he was a pred and he was a discretionary. He would have been a discretionary persistent. So it had to have been.
Well, even if it is, Your Honors, you don't need to find that it was considered.
No, I'm just saying that you're saying there's no indication, but it had to have been because he was a predicate felon and he was a discretionary persistent. So the court had to consider that in determining whether it was going to sentence the defendant as a discretionary persistent, which would have been a life term.
Fair enough, Your Honor,
And
but-
life term.
Fair enough, but in order for this court to find a sentence excessive, it need not be shown or any extraordinary circumstances or any abuse of discretion by not taking these factors into account. The last thing I will say, Your Honors, is that this is why it's important that the waiver be discussed before he pleads guilty. I hear that there's a lot of discussion about, well, wasn't he asked that he understood the waiver and he said yes. I think that once people,
When you argued that the waiver should have been discussed prior to the plea of guilty, you mean prior to the allocution, right?
Correct, yes. Because at that point, I think that sometimes clients are anxious to kind of plead guilty and get it over with. So once they do that, they kind of just know that, yes, no, those are the answers to the questions that they're going to be asked. So to make sure that a client actually understands what they're waiving and what they're giving up, I think it's important to have all of these discussions before he pleads guilty.
Yeah, you know what, and that might be a fair point. So I think perhaps, when you have a client who is pleading guilty, you should request of the court that they go through the waiver first and then conduct the allocution.
Agreed, Your Honor, but however, it's still the duty of the court to make sure that he understands the consequential right that he's waiving.
Agreed. Thank
you.
you both. Century Indemnity versus Brooklyn Union, and Brooklyn Union versus Century Indemnity.
Okay. No, not anymore.
Yes, please.
Thank you, Your Honor, and may it please the court, and Tom Atlisky for Century. New York courts have borrowed the expert disqualification standard from federal courts, which is to disqualify an expert, you have to show the existence of a confidential relationship and that the confidential or privileged information was disclosed to the party by the party to the expert. And the question here is whether to satisfy that second prong of the disqualification test, the moving party must show with some specificity why the disclosures are relevant to and would make any difference in the current litigation.
Is that the New York State standard or federal standard?
It's both.
Both?
So, yeah, so the New York State courts have adopted the two-part standard that has been the rule in the federal courts forever. And the federal courts have held that the second prong of that standard isn't satisfied unless the party seeking disqualification identifies specific and unambiguous disclosures that, if revealed, would prejudice the party.
So you're saying that in this case, Brooklyn Union would have to somehow know exactly what these experts are going to say at a trial, or?
No, not at all. No, so our submission is just that if they just have to show what they disclosed to the expert and then explain why, if the expert then disclosed it to us, it would prejudice them in this litigation. Now, this doesn't normally, in the mine run case, the real egregious case, what you have is a side switcher in the same litigation. So, for example, the Manna case in this court, what you had is an expert who worked for Party A, who got confidential information and also discussed legal strategy with counsel and all that, and then he was hired by Party B in the same litigation. And so obviously, all that strategic information and everything that he got from Party A would prejudice Party B if it was disclosed to Party B in the same litigation. But you don't have anything like that in this case, because Brooklyn Union had hired Dr. Welt and Ms. Blaney to work on environmental contamination litigation, not on this coverage litigation. And the opinion that they're giving in this litigation has nothing to do with anything that they were doing for Brooklyn Union, because their opinion in this litigation is about whether Brooklyn Union's plant operators in the 19th century, early 20th century, expected or intended to cause the property damage that they're being required to clean up now. But in the environmental contamination litigation, that's strict liability. The historical operator's intent just was totally irrelevant, right? So am I saying that it's impossible that they spoke to counsel about something that, if disclosed to Century in this litigation, would prejudice them? No, all I'm saying...
You keep on saying the word prejudice, and you mentioned Manna. I know the two of us were on the Manna case.
Right.
The word prejudice was not in that case. We just focused on two elements: the existence of a confidential relationship and whether information was disclosed. So, we're talking about the federal, but let's focus on the state.
Right, so...
I'm not done. I'm almost done. So, what New York State case talks about prejudice? Because there's only two elements, as I just indicated.
Right, so no New York State case talks about it one way or the other, because no New York State case has considered this question. All I'm saying is that the federal courts that have considered this question...
And some of them have also said that prejudice doesn't apply.
No court has said that, as far as I know. Okay. What I'm saying, what I mean by prejudice is not that they have to show that they were actually prejudiced in the sense that an expert actually disclosed some information. We're not arguing that. All we're arguing is that they have to show that they made a disclosure to the expert that would matter, that would make a difference in this case. The reason that wasn't an issue in Manna is because it was a side switcher in the same case. So it was obviously prejudicial. It would have obviously prejudiced them if the expert had disclosed the privileged information.
But if it was a element or, indispensable requirement for that second element, stands to reason the court would have mentioned it. That's sort of an important concept, prejudice.
And not when it's not. It's not when it didn't matter in the case because it was so obviously satisfied. And I mean, like just to give you an example for why in this case they couldn't have been prejudiced, right? So the only evidence that they say is actually relevant to this case that the experts got was evidence, not evidence, but documents about the historical plant operations, because they say that's also relevant to what the plant operators expected or intended, which is the coverage question in this case. But they don't say that the information that the experts received from Brooklyn Union about historical plant operations was privileged. They say it was confidential, which means it would be disclosed in this litigation under a protective order. And there's only one of three things that could be true. Either they didn't disclose that information to us in this litigation, which means it's not relevant. They did disclose it, in which case we have it, so it's not even confidential. Or they didn't disclose it, but it's relevant, which means they violated their discovery obligations. I assume they're not arguing the third thing. So the only two possibilities are the historical operations information that they received was not disclosed to us because it didn't matter, it was irrelevant to this action, or it was disclosed to us, so it's not confidential as to us, and so there couldn't have been any prejudice.
Thank you.
May it please the court, Your Honor, I'm Dave Luttinger of Covington and Burling, counsel record for the respondents. I'd like
two issues. Was there disclosure?
I would like to introduce my colleague, Mark Mosier, who's been admitted pro in these two cases by court order on the 25th and 27th. We asked permission for him to be able to argue on behalf of the respondents.
Yes, thank you.
Thank you.
Two issues. One, was there disclosure? Was there no disclosure? What occurred?
There was a disclosure of privileged and confidential information to the experts, and that is established in a number of ways through the evidence. We have the time records, the time entry records. We have declarations from Geosyntec, the former employer of the two experts here, as well as the underlying counsel who made the privileged and confidential disclosures to the experts. On this issue of the separate element of prejudice, what the SDNYs in your case would apply the same two-factor test in the New York City policing case, and it rejected precisely this argument that there should be a standalone prejudice requirement. And what the court said there is, if you establish the two elements, you establish that there's a confidential relationship and that relevant, privileged, and confidential documents or information was exchanged pursuant to that relationship, you've shown prejudice. That's enough. And here, we heard that it's a very different situation because they're separate cases. I think it's important to focus on the relationship between the underlying environmental contamination and the underlying environmental case and this coverage case. This coverage case is about who has to pay, whether Century has to reimburse Brooklyn Union for costs incurred in the underlying environmental case. The experts, Welt and Blaney, Welt spent 100 hours working for Brooklyn Union on this matter. Blaney spent 2,000 hours working on this matter. Brooklyn Union paid hundreds of thousands of dollars for the work that they did. In this insurance case, Century is trying to avoid any obligation to pay for Blaney and Welt's work that they did for Brooklyn Union. They want to call Welt to testify to try to get a jury to say that they don't have to pay for the work that Blaney and Welt did for Brooklyn Union. I think if this is maybe where I should have started, but we got off on the other questions, but this question of whether to exclude an expert is left to the discretion of the trial court. The court reviews it for abuse of discretion. We are not aware of any case. The Century didn't cite any case in which an appellate court has reversed the exclusion of an expert for a conflict of interest. And I think the reason why is because the facts matter. The evidence matters. Here we had a judge who sat through a month-long trial at phase one. He knew what these experts were going to testify about. The expert that testified In the first trial, Mr. Suberg testified at length about the historical operations of the MGP sites. Mr. Suberg is available to testify at phase 2. He submitted a report last week, but the jury in the phase 1 trial didn't find his testimony persuasive. So what did Century do? They went out and retained a new expert. And who better to testify about what Brooklyn Union knows about its historical operations than experts that spend hundreds and thousands of hours working for Brooklyn Union on those very sites, got access to privileged and confidential information about the historical operations, and then they want the experts to come in and now testify against Brooklyn Union. If you look at the debate over what the law is and what the facts here, when we first pointed out to Century that, hey, you've hired Welt, who used to work for Brooklyn Union and was one of our consultants, their initial response, the letter they responded, cited the two-factor test that the court applied in Manna. They cited it from Round Point, and they said, this is the test. It's not met here. What they said as to Welt is they said that her prior employer created a screen to make sure she wouldn't get any confidential information. She didn't do anything that had to do with Brooklyn Union. All of that was false. We produced the evidence in support of our motion, the time records that show that she spent 100 hours. She had meetings with counsel. She got access to privileged and confidential information.
Sir, was there anything that the two witnesses learned in their time at Brooklyn Union that wouldn't have been subject to disclosure in either or both of these actions?
Yes, we put this in the record. There is a lot of documents that were privileged and confidential, and we withheld as privileged and confidential in this litigation. The reason that documents that they saw, documents of their work, was produced in this case because they're highly relevant to this case. As I said earlier, we're trying to get insurance coverage for what we had to pay for Welt and Blaney's work. They want Welt and Blaney to testify against us to ensure that Brooklyn Union has to pay for their costs. And so if I can just finish the point on the original response that they gave. Welt, they said she screened off. She didn't see anything. We show the evidence that none of that's true. She worked 100 hours. She had access to the documents. And so how they opposed it, they had a declaration from Welt says she doesn't remember anything. She doesn't remember any of the work she did. We pointed out that as recently as 2022, her resume still talks about the work she did for Brooklyn Union. Her response to that is, I didn't review my resume, somebody else wrote it. On that, I see my time's up, but we would just ask that the court affirm the exclusion of these witnesses.
Thank you.
Thank you, Your Honor. Real quick on the legal point, that New York City policing case that my friend cited, we agree with that case, but it did not hold that if you satisfy the two prongs, you satisfy prejudice. What it said is that the second element of the disqualification test, that, quote, that confidential disclosures were in fact made to the expert, is satisfied only if the moving party can point to specific and unambiguous disclosures to that expert that, if revealed, would prejudice that party. That's a New York City policing case, star 3. Then it went on to hold, when a moving party has demonstrated that it previously disclosed to the expert confidential or privileged information that is relevant to the current litigation, the court presumes that the former client would be prejudiced if the information were revealed. And that's our point. To satisfy the second prong, you have to show specific and unambiguous disclosures. You at least have to show disclosures that were made that were relevant. And the only one that my colleague discussed just now, the only ones that were discussed in the brief, is these historical operations. They say other documents were privileged, not the historical operations. They just say those were confidential. Just look at their declarations at page 36 to 38. Confidential historical operations documents were disclosed in this litigation, and if they weren't, that means they're irrelevant. So either they're irrelevant or they're not confidential.
Thank you. Thank you all.
Thank you, Your Honor.